Good morning, jurors. So I have 3 questions I have to ask you because I haven't seen many of you for a long time, and we do appreciate that you are all here, ready, willing, and able to get started early. We sometimes have to deal with a few things before bringing you in, but we do appreciate your patience. So those questions are, were you all able to follow the instructions and refrain from discussing this case with anyone since we last saw you? Everyone said yes or nodded affirmatively. Were you also able to refrain from doing any independent research or investigation into this case?
Yes.
Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we last met? Everyone said no or shook their heads. Thank you very much.
Jurors, can I have each of you stand and raise your right hands, please? Do each of you solemnly swear you shall well and truly try the issue between the Commonwealth and the defendant according to your evidence and according to the law, so help you God?
Yes.
Thank you. You can have a seat. Jurors, hearken to these indictments. Karen Reed of Mansfield in the county of Bristol, on or about January 29, 2022, at Canton in the county of Norfolk, did assault and beat John O'Keefe with intent to murder such person, and by such assault and battery did kill and murder the said John O'Keefe, and is guilty of murder in the 2nd degree and not in the 1st degree in violation of Massachusetts General Law, Chapter 265, Section 1. 002, Karen Reed of Mansfield in the county of Bristol, on or about January 29, 2022, at Canton in the county of Norfolk, did operate a motor vehicle upon a way as defined in General Law, Chapter 90, Section 1, or in a place to which the public has a right of access, or upon a way or in a place to which members of the public have access as invitees or licensees, with a percentage by weight of alcohol in her blood of 8/100ths or greater, or while under the influence of intoxicating liquor, and did so operate said motor vehicle so that the lives and safety of the public might be endangered, and by such wanton and reckless conduct so described to cause the death of another person, to wit, John O'Keefe, in violation of General Law, Chapter 265, Section 13 and a half. 003, Karen Reed of Mansfield in the county of Bristol, on or about January 29, 2022, at Canton in the county of Norfolk, did operate a motor vehicle upon a way or in a place to which the public has a right of access, or upon a way or in a place to which members of the public have access as invitees or licensees, and without stopping and making known her name, residence, and registration number of her motor vehicle, to go away to avoid prosecution or evade apprehension after knowingly colliding with or otherwise causing injury to John O'Keefe, such injuries having resulted in the death of said person in violation of General Law, Chapter 90, Section 24, Subsection 2, Subsection A and a half, Subsection 2. To these indictments, the defendant has pled that she is not guilty and for trial has put herself upon the country which country you are, and you are sworn to try the issue. If she is guilty, you are to say so. If she is not guilty, you say so and no more. Jurors, hearken to the evidence.
All right, thank you. All right, members of the jury, I'm about to make some preliminary remarks to you to acquaint you with some of the legal principles, procedure, and terminology that you may inquire during the course of this trial. These comments are not intended to be a substitute for the more detailed instructions on the law that I'll give you at the conclusion of the case. So you'll remember that this is a trial of a criminal case. Ms. Reed is charged with 2nd-degree murder. She's also charged with manslaughter while operating under the influence and leaving the scene after causing personal injury or death, the indictments that Mr. McDermott just read to you. I'll describe the law in detail at the end of the case and the elements of these charges, but briefly, murder is the unlawful killing of a human being. In order to prove Ms. Reed guilty of 2nd-degree murder, the Commonwealth must prove beyond a reasonable doubt that she committed an unlawful killing and that it was done with malice. In comparison, manslaughter while operating under the influence is an unintentional, unlawful killing caused by wanton or reckless conduct while under the influence of intoxicating liquor. And leaving the scene of an accident after causing personal injury or death requires the Commonwealth to prove that Ms. Reed knowingly collided with John O'Keefe, that she caused him injury or death, and then she fled the scene. These terms and the elements of the crimes will be explained to you in detail at the end of the case before you begin your deliberations. Now, please remember that Ms. Reed starts this trial presumed to be innocent. The fact that she was arrested or that she was indicted is not proof of anything. An indictment is just a piece of paper. It just makes an accusation. It is merely a formal manner of accusing a person of a crime and bringing that person to trial in the superior court. But it is only the jury, in other words, you folks, who can decide whether the prosecution has proved its case beyond a reasonable doubt. If the Commonwealth does not do that, then the presumption of innocence alone requires you to find the defendant not guilty. The law never requires a defendant to prove her innocence, to produce any evidence whatsoever, or to do anything other than attend the trial. This presumption of innocence remains with the defendant until you, the jury, make your determination after listening and considering all the evidence. Now, what is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I have told you that every person is presumed to be innocent until he or she is proved guilty, and that the burden of proof is on the prosecutor. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt. Now, our system of justice depends on judges like me and jurors like you being able and willing to make careful and fair decisions. All people deserve fair and equal treatment in our system of justice, regardless of their race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. You have agreed to be fair, and I am sure that you want to be fair, but that is not always easy. One difficulty comes from our own built-in expectations and assumptions. They exist even if we're not aware of them and even if we believe we do not have them. Some of you may have heard this called implicit bias, and that's what I'm talking about. Of course, we judges have the same problem as everyone else, so let me share a few strategies that we have found useful. First, slow down. Do not rush to a decision. Hasty decisions are more likely to reflect stereotypes or hidden biases. Second, keep an open mind. Avoid drawing conclusions until the end of the case when you and your fellow jurors deliberate. Remember that when you deliberate, you will have all the evidence and all the time you need to make a careful decision. So there truly is no need to stop making up your mind before then. Third, you should listen closely to all the witnesses. That is the best way to ensure that you decide this case based on the evidence and the law instead of upon unsupported assumptions. Fourth, as you listen to the testimony about the people involved in this case, please consider them as individuals rather than as members of a particular group. And finally, I might ask myself, would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender identity groups? At the end of the case, I will remind you of these strategies and ask you to focus on the evidence instead of any unsupported assumptions you may have. All we ask is that you, individually and as a group, do your best to resolve this case based upon the evidence and the law, without sympathy, bias, or prejudice, to the best of your ability as human beings. Now, when I finish these initial instructions, the Commonwealth, Mr. Brennan, will make his opening statement, then Ms. Reed's lawyer, Mr. Jackson, can choose to make an opening statement or not, because again, remember, the defendant has no burden of proof and doesn't have to prove anything. Her lawyer does not need to make an opening statement. An opening statement is a summary of what the lawyer expects the evidence at trial will be. It is intended simply to introduce the main issues in this case to you. Next, the prosecution will introduce evidence in support of the charges in the indictments. After that, the defendant may present evidence on her behalf if she wishes to do so, but she is not obliged to do so. Remember, the burden of proof is always on the Commonwealth to prove that the defendant is guilty. The law does not require any defendant to prove her innocence or to produce any evidence at all. After all the evidence, each side will have an opportunity to offer you closing arguments about what conclusions you might draw from the evidence. Like the opening statements, the closing arguments are not evidence. They're merely intended to help you understand the respective contentions of the parties. Finally, after all the evidence and the lawyer's arguments, I will instruct you in detail on the principles of law which you are to apply in your deliberations when you retire to consider your verdict. Your verdict must be unanimous. Let me speak briefly about our respective roles in this case. As the judge, my responsibility is to see that this case is tried orderly, fairly, and efficiently. It's also my instruction to decide any questions of law that come up during the trial and to instruct you about the law that applies to this case. It is your duty to accept the law as I state it to you, whether you agree with it or not. Your function, you folks are the most important people in the courtroom. Your function is to determine the facts. You are the sole and exclusive judges of the facts. You alone determine what evidence to believe, how important any evidence is that you do believe, and what conclusions all the believable evidence leads you to. You will have to consider and weigh the testimony of all the witnesses who will appear before you, and you alone will determine whether to believe any witness and the extent to which you believe any witness. You can believe all of what a witness says, some of it, or none of it. It's entirely up to you. It is part of your responsibility to resolve any conflicts in testimony that may arise during the course of the trial and to determine where the truth lies. Ultimately, you must determine whether or not the Commonwealth has proved the charges beyond a reasonable doubt. The lawyers have their own important role in this trial. They are, of course, advocates. Their job is to bring to your attention the evidence and arguments that best support their position. They may also object to evidence offered by the other side that may not be admissible under our rules of evidence. Similarly, we may engage in sidebar conferences out of your hearing. These sidebar conferences are not intended to keep secrets from you, but to allow the lawyers a little more time to argue their points so that I may rule on what you may consider as evidence. If I agree with an objection to a question, the term I will use is sustained. You are to disregard that question, and you're not to speculate as to what the answer might have been. In the same way, you're to disregard any evidence that I tell you is stricken from the record. If I reject or overrule an objection, I'll permit the witness to answer. This happens a lot. You'll find this during the course of the trial. If I let the witness answer the question, but you're not allowed to give the answer any more weight than you would have no objection had been made. Please do not hold it against the lawyers if they make an objection. That's the important part of the lawyer's job. The lawyers have to let me know when there is a potential issue about the admissibility of certain evidence under our law. You must decide this case solely on the evidence presented in this courtroom. This will include the sworn testimony of witnesses and may also include any exhibits that are admitted into evidence, any facts that I tell you have been agreed to by both sides, and any facts that I indicate to you may be taken as a matter of common knowledge. Questions to witnesses, no matter how artfully phrased, are not evidence. Only the answers which you receive from the witnesses who are testifying under oath are evidence. So, if a witness is asked, isn't it true that after you learned that your uncle left you money in his will, you poisoned him? And the witness's answer is no. Based solely on that question and answer, there is no evidence that the witness has an uncle, that the uncle had a will, that the uncle left the witness money, that the witness knew that he did, or that the witness poisoned him. Any information that you may have read, heard, or seen about the case outside of the courtroom is not evidence. My instructions to you and any other comments I may make, the lawyer's openings and closing arguments, and any comments they may make are not evidence. I will emphasize this point because it's crucial to your understanding of your role. If the lawyers or I make any comments during the trial, those comments are not evidence, and your verdict must be based only on the evidence. In Massachusetts, lawyers are not allowed to make comments other than during opening statements and closing arguments. They are permitted only to ask questions, but they cannot comment on the witness's answer. If a lawyer comments, you are to disregard it. In this way, communication in the courtroom is not like everyday conversation. If a lawyer seems to agree or disagree with an answer, or if a lawyer expresses confusion or any other reaction or emotion, you are to give no weight to what that lawyer does. In the interaction between a lawyer and a witness, you may consider only the witness's testimony as evidence. In a similar way, any comment I make is not evidence. But of course, you can't disregard what I say when I provide you with instruction or direction. Remember, however, I'm the only one who can instruct you or direct you in any way. Finally, on this topic, if one of the lawyers or I refer to some part of the evidence and that does not coincide with your own recollection, it is your collective recollection which you are to follow in your deliberations. Now, in this case, I anticipate that we will go by bus to an area that you'll hear about during the trial. You may consider as evidence anything that you observe about the layout of the area, including the scene of the alleged crime when we do go there. I will give you further instructions prior to our leaving for the view. Now, in this case, I'm going to allow you to take notes. Any jurors who wish to take notes during the course of the trial, except during opening statements and closing arguments, because remember, those aren't evidence. If you wish to take notes, you may do so once the evidence begins. Notebooks and pencils will be provided to you. The notebooks will be collected each day, and they'll be locked up, and they will remain confidential, and they're destroyed at the end of the trial. Nobody sees them. You're not required to take notes. The choice is entirely up to you. Some jurors may feel that notes are helpful, particularly if the case involves many witnesses or complicated issues. Notes also can help you remember specific testimony or evidence, such as times, places, dates, names, relationships, events, distances, things like that. Other jurors may feel that note-taking is a distraction and may interfere with hearing and evaluating the evidence. If you do take notes, I suggest you keep them brief. They are not and cannot be considered official transcripts of the trial testimony. However, bear in mind that although the court reporter is recording everything that transpires here, we do not have the capability of providing you with a transcript of the testimony at the conclusion of the trial. So you'll have to rely on your own memories of the testimony, perhaps supplemented by your notes. Regardless of whether or not you take notes, please remember that how a witness testifies may be just as important as what he or she says. Therefore, your observations of the witness's appearance and demeanor on the witness stand may play an important part in your assessment of his or her credibility. Do not let note-taking distract from an appreciation of all the evidence. If you have any trouble hearing or seeing during the trial, please raise your hand or let a court officer know, and we'll make any necessary adjustments. We generally take a morning recess at around 11 o'clock or so, but if you need a break at any other time, please raise your hand and let a court officer know. We'll take a break. If you need to communicate with me during the trial, and I'm not suggesting for a minute that you need to, but if you do, please speak with the court officer or give the court officer a note to bring to me. Now, I'm going to address the issue of public interest in this case again, and the duty of this court and this jury to adhere to the rule of law, because it is so very important. John Adams famously said that we are a government of laws, not of men, and that the law must be deaf as an adder to the clamoring of the public. He meant that while public opinion about a given subject may ebb and flow, the law must be steady, reliable, and even-handed. We know that on the subject of this case, there are people advocating for one outcome or another with great intensity, but unbound by any oath or even any inclination to follow the actual evidence. The law works in a different way, and the difference is crucial to our system of justice. This jury, selected for this trial, will hear and judge the evidence. You will decide what the facts are. Where the evidence is contested, you will determine where the truth lies. Ultimately, This jury will decide whether the Commonwealth has carried its burden of proving that the defendant is guilty of any crime beyond a reasonable doubt. People outside of this building have rights, and we know that they have voices, but this trial will be decided by you, an independent jury, free from outside interference, based only upon the evidence presented in this courtroom and the law. This is the only way to ensure that every person who comes before the court receives a fair trial. It is just that simple and that important. So while public comment will likely continue, you must ignore it so that the rule of law will be upheld. Which leads me to the fact that it is very important that during this trial, until you deliberate, you must not discuss this case with anyone. This includes your family and friends, and even your fellow jurors. Nor should you allow anyone to communicate with you about any specific aspect or any aspect of this case. You must not conduct any independent research about this case, the matters in this case, and the individuals involved in this case. In other words, you must not consult the internet or do anything else to try and find out information from any source outside the confines in this courtroom. Please be very careful with your social media use. Please do not use X or Twitter, Facebook, Instagram, or Reddit. Though you may never have seen anything about this case before on your social media feed, you cannot control what may pop up. You should also remember that use of these platforms can be public and traceable, and any searches undertaken or information received by you can and likely will be discovered. So please be extremely cautious. If you inadvertently see something about this case, please disregard it and let us know. As best as you recognize them, please have no contact with any of the participants in this trial or anyone associated with either side, including the lawyers. Please do not visit any locations that may be mentioned during the trial. We'll go on a view, as I told you, and I'll discuss that with you before we go. Remember, you were instructed that you must not, and you assured us that you would not read, watch, or listen to any account of any aspect of this case in any news media, social media, or from any other source. It is critical that you follow that instruction. Finally, please continue to keep an open mind. I know that you will try this case according to the oath that you've just taken as jurors. When you took that oath, you promised that you would well and truly try the issues between the Commonwealth and the defendant according to the evidence and the law. If you follow that oath, approach this case with an open mind, and make your decisions fairly and without prejudice or bias or sympathy for anyone, then you will arrive at a true and just verdict, and that's all we ask of you. So it's now time for the opening statements. Mr. Brennan.
Thank you, Your Honor. At 6:04 a.m. on January 29, 2022, the alarm bell sounded in the Canton Fire Department. Firefighter paramedic Timothy Nuttall knew what that meant. His heart skipped a beat, he raced to his equipment, and he picked up his bag, which was meticulous. There was a sign and a signal, and then there was a voice commanding that there was cardiac arrest. The most serious of calls for a firefighter paramedic, that means that a person's heart has stopped. He didn't know who it was, he didn't know where it was. He took his bag, he had just gotten to the station, and he rushed to the ambulance. He was one of the most senior paramedics that morning. Another paramedic, Anthony Flamati, would be running this mission. He jumped in the back of the ambulance, the door shut, and they headed off to 34 Fairview Road. As they drove, firefighter Nuttall could not see anything. He couldn't hear anything other than the engine of the ambulance. He could feel it sliding across the road. It was near blizzard conditions. He calmed himself, he steadied himself. This is what the firefighters and paramedics are trained to do, to focus. And he focused on his task. He looked around the back of the ambulance to make sure all the tools were in place. The ambulance was meticulous as well. This was Anthony Flamatti's ambulance, and it was well stocked. He calmed himself, and he thought about what was going to happen. What should he be looking for? What is his next steps? He played the scenarios through his mind, and eerie calm was above him. As the car pulled up to 34 Fairview, the ambulance, he stood at the back door, and the doors open, and he stepped out into bedlam. He could hear a woman screaming and shrieking, the cold, hard air slapping on his face, and the wind, blizzard conditions swirling around him. You will hear him tell you how he trudged towards those screams in the darkness to snow, and when he got there, he saw 3 women surrounding a man lying, not moving on the ground. He walked up to the man, and he reached down, and he tried to find any signs of life, pulse, anything, and he found nothing. And he got up and he walked over to the woman, and he walked over to that defendant, Karen Reed, and he told her that he thinks that that man is gone. And then he heard the yell from Anthony Flamatti, the chief, and he said, "Come back, let's go." Because you'll learn that in the cold, even if somebody's heart stops, even if they're presumed to have passed, sometimes you can still save a life. So you'll see on a dash cam video, you'll hear through testimony, he went back to that man who's John O'Keefe. He went back to him, and that crew, coordinated effort, they did everything they could to save his life. They got on their knees, they began CPR, and firefighter Nuttall will explain as he kneeled over John O'Keefe, he looked up, and the defendant approached him, and you'll see it on the video. Now, he wanted any information, because when you're trying to save someone, you want to know, are they on drugs, medication, do they have a heart condition? And he looked up at Miss Reed, and he said, "What happened?" And you'll hear her words to firefighter Nuttall. She said, "I hit him, I hit him, I hit him." And it was at that time, with the words of the defendant, that she admitted what she had done that night, that she hit John O'Keefe. Now, those words didn't mean anything to firefighter Nuttall. They weren't in context, they didn't reconcile with the injuries, it didn't help him in his treatment, so he ignored it. Now, firefighter Nuttall is not a police officer. He is not an investigator, he is not a detective. He's a first responder. And so he takes that information, it was useless to him, he continues to work on John O'Keefe trying to save his life. You'll see the team put him on a stretcher, and when they lift him from the ground, even though there is snow accumulating, underneath John O'Keefe is simply grass, hard, brown, frozen, and beneath his body lay his cell phone. They bring him to the ambulance, and while they bring him to the ambulance, you'll see on the videos that other first responders speak to the defendant. One first responder, Mr. Flamatti, she will say, "I hit him, oh my God, I hit him." And then she was interviewed or asked questions for background information, not a criminal investigation, just background to try to help John. And she was asked questions about his background, and during that conversation, you won't hear her see the defendant with a person by the name of Jen McCabe and a firefighter McLaughlin, and she tells Fire McLaughlin, the third first responder, "I hit him." They bring Mr. O'Keefe to Vince Meriden Hospital, and his body is cold. The doctors work feverishly. They treat him, trying to save him. They try to warm his core. And unfortunately, firefighter Nuttall's first instinct was accurate. John O'Keefe passed. So why are we here today? We are here today because John O'Keefe was killed by the actions and conduct of that defendant, Karen Reed. You will learn through this case, through facts, science, and data, you will learn that on January 29th, 2022, when the defendant and Mr. O'Keefe were in front of 34 Fairview Road, all the way to the left side in a dark corner near a flagpole, you will learn that Mr. O'Keefe got out of the car. He got out, and he stood by the side of the road after an argument with the defendant. That argument, that anger fueled by heavy intoxication, you will learn from the science and data as he stood by the side of the road, the defendant in her SUV drove away. She drove at least 35 feet away. The argument was over. It had ended. But then she stopped. She stopped, she put the Lexus into neutral, and she waited for 2 seconds. And the facts and the science and data will tell you that despite the fact the argument was over, she then put the Lexus into reverse, put her foot on the gas pedal, and began to press, not 25%, not 50%, up to 75% acceleration. There was a light dusting of snow, the Lexus tires spun backwards, she went backwards at least 70 feet, she clipped John O'Keefe, he fell backwards, hit his head, broke his skull, and there he lay at the corner of Fairview Road, on the ground, lying on top of his cell phone, alone. And then the defendant will later tell that when she left, he didn't look mortally wounded, yet he was. And she simply drove away. Now, before I tell you about the data and the facts and the science, and I walk you through that, I'd like to tell you a little bit about John O'Keefe. John O'Keefe was a young man, a local kid, very well liked, loved. John O'Keefe is the son of Peggy O'Keefe, John O'Keefe Sr., and the brother of Paul O'Keefe. Grew up in Canton, worked hard, he became a police officer. But what you're going to learn, the fact that he worked for the Boston police officer, as a Boston police officer, was just a fraction of his life. It was a small, really unimportant part, because the biggest part of John O'Keefe is he was a family man. Not in the traditional sense. You see, John O'Keefe never had biological children. John O'Keefe was never married. But John O'Keefe had a sister, and she had 2 children. And when the children were 6 and 3 years old, his sister unfortunately died. And shortly after, his sister's husband died. Now, John O'Keefe was a helper. He didn't sit by. He saw these 2 recently orphaned children, and he stepped in and he said he was going to raise them. So he put aside his career, he put aside his job, and he moved in with the children and raised them like they were his own. They were his passions, his love. He was a new parent, successes, failures, like all parents. And he raised the children with the help of people in the community, with the help of his brother, with the help of his family. And they led a good life. Enter Karen Reed. Around COVID, the defendant and Mr. O'Keefe reacquainted, and they started a relationship. And you'll hear that even though the defendant had her own home, she was staying with Mr. O'Keefe a lot, 4, 5, 6 times a week. And to most of the world, it was a pretty good relationship. They spent time together, they did activities with the children together, she helped with driving the children, feeding the children. It was a steady relationship until about the beginning of 2022. And then things began to unravel. There was tension, there was arguments. In fact, just a few days before this incident, you'll hear that Mr. O'Keefe asked her to leave, but she wouldn't. You're going to be able to read text messages of their conversations on January 28, 2022, and you will see the tension and the unraveling of the relationship. You will read about the discord between the defendant and Mr. O'Keefe. You will see that when he would ignore her calls, they would become incessant. When he would try to push away, she would come closer. You will read those text messages and you will realize that this was the beginning of the end of this relationship. That night, they decided they would go out together. I want to tell you something about data and science before we get to that night. I mentioned that underneath John's body was a cell phone. A cell phone is an amazing piece of technology. It is like a computer. it carries extraordinary data. And when they found the cell phone, the only companion to John O'Keefe that night, they studied the cell phone, and there'll be some remarkable data that you will use in this case to find the truth. I want to mention 3 different things you will find in a cell phone that are critical to this case. The first is called location data. Waze we've all heard of, Google Maps. Well, at some point that night, John put his Waze on, and Waze is like a breadcrumb. It will show exactly where the phone goes, second by second. It is the strongest, most accurate location data that you can have. And that night, John was using Waze. It also will have healthcare data. Healthcare data will show when somebody is moving. Sometimes it's qualified as steps, but it doesn't necessarily mean somebody's stepping. Moving their arms, walking, turning. It doesn't show what direction or how far, but it shows movement of a person. Healthcare data. And the third thing, remarkably, there will be an expert in this case who found a data file on the phone, and it tracks the temperature of the cell phone battery. That will be critical to your analysis in this case, the temperature of the cell phone battery. And so with that, I want to take you back to the timeline of that night. After the discord, both the defendant and Mr. O'Keefe decided they would meet at a bar called McCarthy's. Now, McCarthy's is a local bar, a blizzard is pending, and people are getting together in a celebratory mood. They go to McCarthy's, and you'll see a video of McCarthy's, and you will watch both Mr. O'Keefe, friends, and the defendant drinking alcohol. And you will count 8 vodka drinks that the defendant drank. They arrive at 8:50, they stay till 9:45. She consumed at least 7 of those drinks in less than 2. The last drink, you'll see when they leave the bar, she puts it under her jacket, and they walk out and they go to another bar to meet other friends called the Waterfall. They reach the Waterfall sometime around 10 p.m. And when they go into the Waterfall, you'll see a video. And when I said celebratory mood, you will see a group of friends of John O'Keefe, many who are friends with Karen through John, and you'll see them clapping and happy and joyous that they're there. You'll see many hugs between John O'Keefe and his friends and the defendant and many of the people there. And they spend some time together, there's drinking, and they all do a shot. And that will be at least the 8th drink within 3 hours that you consume. You will see from the data, not just the cell phone data, but there's some other very important data, and the other piece of data that goes hand in glove with the cell phone is information on the defendant's Lexus vehicle chips. You might have heard of black box in an airplane, where there's some type of event that captures a small amount of time. Well, that was captured in the defendant's Lexus. That black box information with the cell phone data will tell you everything you need to know in this case. It will bring us step by step through the entire night to the death of John O'Keefe. And so they leave the Waterfall Bar at 12:12, and you'll see that the ignition goes on to the defendant's Lexus. And both John O'Keefe and the defendant in the car, and they decide that they're going to go back to 34 Fairview Road, where we talked about earlier. They're going to go there for a get-together for one of the homeowner's sons who's having a birthday party. And so as they drive back, you will be able to follow them with this location data. When they go back to Fairview, they don't know exactly where it is, and they get lost. And so John O'Keefe makes a phone call, has a phone call with one of his friends, Jen McCabe. And during that phone call, which the defendant listens to because she recounts it, and trying to get directions, Jen McCabe tells John O'Keefe, it's near Bella's mom's house. You'll learn that Bella, or her mom, was somebody that John had dated before this week. And so as they make their way through Fairview, you will see there's a road that comes down like a loop and that leads to Fairview. They take a wrong turn on the loop, and then they do a 3-point turn in the driveway. You'll see the exact precise driveway they turn into because some type of acceleration movement triggered that black box in the Lexus. And that's important because that's 7 minutes before the collision. And you'll see from the Waze exactly where the car was. You'll see from the black box the event of the 3-point turn in the driveway, and then a return down to Fairview. But before they get there, At 12:23, a truck is coming the other way. And the witnesses in that truck will say they blinked the lights, one of them saw a man and woman in the car, John and the defendant, and then they followed the Lexus because they were going to the same house. The truck stopped at the driveway, and the Lexus, the defendant's car, will appear because of the waves and be counted second to second, never stops. It rolls very slowly all the way to the end of the yard in the corner where there's a tree line and a flagpole. And they reach that location at 12:34:33. And they're in the car and they stay there. The truck waits, they speak to somebody in the house who comes out, the person goes back in the house and they're there for about 5 minutes. We're now down to 2 minutes before the collision. The truck leaves, and now it's just the defendant and John. And while they're waiting outside, 12:27, John gets a text from Jen McCabe. Park behind us in the driveway. 12:29, she texts again. Are you coming in? You'll hear that Jen McCabe and others look out the window and see the defendant's Lexus in front of the flagpole at the far end. It's snowy, it's dark, it's windy, they're waiting. You will know that John O'Keefe was in that car, that Lexus, and didn't move because his healthcare data is not moving. It's not moving until 12:31:56. At 12:31:56, he begins to move. He will have 20 seconds before he falls. 20 seconds. He gets out of the car, the Lexus, and in that 20 seconds, you'll hear that user initiated. He looks at the phone, at the text message to Jen McCabe. It is now 12:32:09. He closes the phone the last time. It will be the last time he uses that phone. From the waterfall bar, you see that he keeps it in his back pocket. And at that time, 12:32:09, last user, he has 7 more seconds he will move before he lies dormant the rest of the night. We'll also have the information from the defendant's Lexus black box. And the clocks run differently. There's a 30-second variance, but it's right in the heart of that time. And you will see through the data at that time, when he makes his last movements with the phone, is when her car leaves 34 feet at least, stops, neutral, and then shoots into reverse with the tire spinning right towards him, right where he got out. You'll know they're arguing because the next morning she tells the firefighter, I'm sad because our last moments were fighting. She drives away. And they said, she's made later statements that when she left, he didn't look mortally wounded. He lied on the ground on top of his phone, light dusting of snow, the snow now picking up. And he's just there. It's 12:37. Now, when he's in the car, before he gets to Fairview, the battery temperature of that phone is 77 degrees. 77 degrees in the warm car. Now that he's been outside the car for 5 minutes, it drops to 72 degrees. She drives to his house. She makes a phone call at 12:33 after she's left Fairview. She calls again at 12:36:33 and leaves a message. You'll hear it. And you will hear the anger and rage in her voice. She leaves a message. John, I fucking hate you. Pardon my language. You will hear the simmering. And she leaves that message. He lies on the side of the road. He gets another text message that's unanswered to Jen McCabe. Where are you? 12:45. Battery temperature, 61 degrees. Stop. He gets almost 40 calls from the defendant that night. His phone rings, but he never answers. You'll hear from an expert that the light never initiates, the healthcare data never moves. John alone with his only companion, his phone. At 12:53, cell phone drops to almost 60 degrees. 12:59, the defendant leaves another message on John's phone. Now, she hasn't spoken to anybody. Nobody has spoken to her. But her message is telling. You'll learn her message says, John, nobody knows where you are. And this is where the plot and the cover-up begins. The evidence will make clear that she knew he was there, but she did not call 911. She did not go back to him. She did not leave an anonymous tip. She left him. The night wears on. It's now 1:07. Battery temperature 55 degrees. 1:14, she calls her mother. No answer. 1:14:53. Battery temperature 50 degrees. The defendant had healthcare data on her phone as well, and you'll hear that it stops around that time. And you later learn that she admits to falling asleep and passing out. But then she wakes. 5 o'clock, she is frantic. She wakes up John's niece, and she is unintelligible. She is yelling, she's screaming, she asks for the niece to call Jen McCabe. She calls Jen McCabe, and you'll hear Jen McCabe recount. Out of her deep sleep, she wakes up and she hears, Jen, 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 screaming Jen's name. John's dead. Hangs up the phone. Jen McCabe calls back. And then she, what's going on? And she told, well, I left him at the waterfall at the beginning of her. She tells Jen McCabe, I left him at the waterfall. Jen calls back and says, he saw you up front. You did leave him at the waterfall. She hangs up. She then minutes later calls another person, Kerry Roberts, a friend of John O'Keefe. Someone who's not friends with the defendant, but they know because they helped raise the kids and they interacted. She had nothing to do with the night before, wasn't at the bars, was home with her family. She calls her and says, I think John got hit by a plow. I think he's dead. Now Kerry, with that information, calls 911. She calls hospitals. You can hear her voice. She's concerned, not panicked. And then she gets another call from the defendant. And she tells the defendant, come to my house. I will help you look for him. And the defendant says, I was so drunk last night, I don't remember anything. Waiting for her to arrive, she learns she doesn't arrive. Instead, the defendant goes to Jen McCabe's house. Kerry Roberts, the other friend, then goes to Jen McCabe's house, pulls behind the car. And when she does, she's on Bluetooth, and she can hear the defendant say, my taillight's broken, my taillight's broken. And she looks, and the snow packed in the right taillight, she can see a piece of the taillight missing. The defendant desperately wants to go to 34th Fairview Road, but Kerry Roberts takes over and says, we're going to go back to John's house. Maybe he's in the house when you didn't see him. So both cars, driven by Kerry Roberts and then Jen McCabe, with the defendant, go back to John O'Keefe's house. You'll see a ring video where you see them go into the house and they look around, and you'll hear about the woman, Jen and Kerry, enlisted into this task. Look for John O'Keefe. They cannot find him. And then when Kerry Roberts comes into a room, she sees, rather than looking, the defendant simply standing there, staring at the wall. At that point, the defendant insists they got to go back to Fairview Road. They decide they'll take one car. Kerry Roberts is taking charge. She's going to drive. They leave Miss Reed's Lexus in John O'Keefe's driveway, and they drive back towards 34th Fairview Road. You'll hear it is blizzard-like conditions. It is dark. They can barely see a thing. And when they get close to the edge of 34th Fairview, you hear the defendant start to scream, there he is. Both women look and they can't see anything. She starts kicking the door. The defendant's kicking the door, let me out. Kerry Roberts stops the car and lets her out, and she sees the defendant run exactly to where John O'Keefe is in the darkness. Just where she left him. Kerry gets out of the car, starts to walk towards where the defendant is, and she sees the defendant lying on a body. She can't tell who it is because the face is still covered with snow. And she comes over and looks, and she wipes off the snow from John O'Keefe's face. She realizes he's one of her best friends in the world is John O'Keefe. And she starts to try to do first aid. They start to move him, and coincidentally at 6:06 when they start to move him, the cold air hits that cell phone battery. It drops from 50 to 43 degrees. And they try, Jen McCabe calls 911. And that's when a police officer arrives, firefighter Nuttall and his crew. And when they lift him, that cell phone battery that is shot down to 37 degrees, Kerry Roberts picks it up and puts it in her pocket. and it immediately starts to warm. As she moves, the healthcare data showing movement starts again. At that point, nobody knows what happened. The Canton Police Department come. You can see the police cars and cruisers. They're not sure, so they look in the area where John's body is and they find a glass from the bar near his body. They find blood spots. They try to put the blood spots in plastic containers. They don't know what they're looking for at this point. There's no information. They don't believe or know that there's a crime. They just know that John O'Keefe somehow ended up here with the broken glass and the blood. And so that morning, you can see the work of the Canton Police Department try to uncover a little bit around his body to see what they could find, which was very little. And then, Terry Roberts goes and picks up Peg O'Keefe, tells her the news, and they go to the hospital. They go to the Good Samaritan Hospital, and Terry Roberts is walking, and Peggy O'Keefe is going to go see her son, with her husband. And as she walks down the hall, Karen Reed is also at the hospital. See, there was some reports of maybe she was upset or suicidal, so they sectioned her. They put her in for evaluation to make sure she was safe. You'll hear Peg O'Keefe tell her she walked down the hall to go see her son. The defendant was screaming, "Is he dead? Is he dead?" As she walked by Karen Reed, she stopped and she said, "Karen, what happened?" And you'll hear that Karen was excited and yelling, "Is he dead?" Stops her excitement, becomes stoic, doesn't say a word. Peggy pays respects to her son, and then she has to go back home because she has to tell the children. Now, while she's out, the Canton Police Department sent an officer to the house to make sure the children are safe because they're alone if they're home. And when the officer pulls in, he doesn't notice anything, but you'll see on the dash cam video, his dash cam video notices something. That tail light has a big missing piece to it. They can't find the children. Ultimately, Peggy comes home, a friend had taken them, and they bring the nephew home, and he is distraught. And then Peggy hears a knock on the door. It is the defendant and her father. They want to come in. They come in, no condolences to Peggy, and they ask, "Can we go upstairs to John's room?" And she's busy consoling her grandson. They go upstairs. They're upstairs for about 15 minutes. They come down, and quickly they leave. Now they got there from the defendant's father, drove his wife and the father to that house. But when they leave, they take two cars. They take the Lexus with the broken taillight with them back to the defendant's father's house. And you will learn that when police start getting some of the information, they learn about the broken taillight, they learn information that she had told people that she had hit him. They went down to see her. And on their way down, they decided they would get a warrant to take the Lexus. When they get down to Dayton, where the car is, you'll hear from Trooper Buchanan. He took a look and you can see the missing taillight. They went in and spoke briefly to the defendant. They took the car, they brought it back to Canton. And so, what you'll learn from the forensic evidence that will help with the science and data is that not only was a cell phone left behind, but also around that area, broken taillight was littered around John O'Keefe's body. Littered around that area. When they got into the hospital, they noticed there was a shoe missing. As time went by, snow melted, they dug with excavations, they found his shoe on a little berm on the border between the street and the grass. You'll learn days later when they did a plant excavation, they found his hat frozen into the ground. Ultimately, they would find over the course of 10 days that the snow melted almost all every piece of that broken taillight in that area. His hat, the sneaker, the glass. When the defendant left Mr. O'Keefe behind, he took with her something of Mr. O'Keefe. called trace evidence. You'll learn on the back of her Lexus, around the taillight area, is John's DNA, and stuck to the side, grasping one last piece of John O'Keefe's hair. Now, John O'Keefe fell backwards, hit his head after he was clipped by the car. And you're going to hear from a very renowned doctor, a neurosurgeon, who has treated thousands and thousands of head injuries. And the wound on the back of the head, when he fell backwards, from the cracked skull, it's called a basal fracture, to create an injury called counter-coup. After he was clipped by a car and fell backwards and hit his head on that hard rock ground, remember there's no snow, it's just a dusting at this point, the back of his brain hits the back of the skull and bounces up. When it bounces up, it leaves marks showing that impact. And this neurosurgeon will tell you, treated thousands of patients, that this injury, to a reasonable degree of medical certainty, is counter-coup caused by falling backwards and hitting your head. When the medical examiner for the state looked at it, they generally said blunt force trauma. They had it as undetermined. And so we brought it to a renowned neurosurgeon who does exactly this. You're also going to hear from an accident reconstruction. His name is Judd Welcher. He does not work for the state police or local police. He was hired to take a look at this case and the data. He will come in and explain to you exactly what I talked about, how the data from that black box coincides with the cell phone and the movements of the car, the moments before, during, and after the defendant struck John O'Keefe with her car. Now, just a few more things I want to share with you. There are 3 charges against the defendant in this case. The first one, second-degree murder. When most people hear murder, they instantly think shooting somebody, stabbing somebody, deliberate premeditation. Our Honor will instruct you on the law. I'm not going to trample in that area, but I can tell you clearly, we are not going to try to prove that Karen Reed tried to kill John O'Keefe. We're not going to try to prove to you that she intended or wanted him dead. That's not second-degree murder. What we will prove to you is she engaged in an intentional act, driving back at him at that speed, in the storm, in the darkness, knowing that he had just gotten out of her Lexus. She intended that act, which would cause a plain and strong likelihood of death. That's what we will prove to you for second-degree murder. Also, operating under the influence of alcohol, manslaughter will prove to you that she drove her Lexus recklessly. She hit John O'Keefe, and because she hit him and he fell back, she caused his death. The third charge is leaving the scene after knowingly causing death. Again, she hit Mr. O'Keefe with a car. She knew he was injured. She left him behind, and he died. That's what we'll prove. This case will come down to the science and the data. The science and the data, the cell phone is the best of historians. It doesn't suffer from intoxication. It doesn't suffer from memory loss. It doesn't suffer from emotion, pride, or prejudice. It is facts. It is data. And that facts and data will lead you to the truth in this case. But after Ms. Reed was charged, she began what you'll learn as a campaign. A campaign to make public statements. 2020, Nightline, Fox 25, a documentary. And we've had an opportunity to get many of her statements in the footage, and we're going to show much of it to you. And her statements to you will confirm what you already know from the science and the data, what you will already conclude from the facts independent about what she did that night. Her word will simply confirm that your judgment is sound. And you're going to hear from her own lips in many of her statements, her admissions to extraordinary intoxications, her admissions to driving the Lexus, her admissions to being angry at John that night. And I dare say her admissions that she told she had killed him. I'd like to play for you clip 1. You're going to hear the first of the statements that she made after she was charged.
I mean, I didn't think I hit him, but could I have clipped him? could have tagged him in the knee and incapacitated him. He didn't look mortally wounded as far as I could see, but could I have done something that knocked him out and in drunkenness and in the cold didn't come to again?
And this would have been the moment you dropped him off at the party. You're thinking.
Yeah, would have had to.
Ladies and gentlemen, I simply ask you to follow the evidence, follow the science, follow the data. Ignore speculation, surmise, conjecture. Stay true to the evidence. It will lead you to the truth. That on January 29, 2022, a very intoxicated defendant was angry and arguing about the relationship with John O'Keefe. And after the fight was over, she left, but she brought the fight back to him in the form of her SUV. She clipped him, he fell backwards, he broke his head, and then this man who helped, a lifetime of help, was left at the corner of that yard, left to die with no help. The facts, the data, and the evidence will bring you the truth, and the defendant's own words will confirm everything you've already concluded.
All right, thank you, Mr. Jackson.
Could I have just a moment to readjust?
Sure, the court officers will be kind enough to help you.
May I, Your Honor? The evidence in this case will establish above everything else 3 points. There was no collision with John O'Keefe. There was no collision. There was no collision. John O'Keefe did not die from being hit by a vehicle. Period. The facts will show that. The evidence will show that. The data will show that. The science will show that. And the experts will tell you that. You'll learn that the Commonwealth has pinned its entire case on a brazen and a flawed assertion that is untethered, unconnected to the facts and to the evidence. And their assertion is contrary to science. Because at the end of the day, folks, there was no collision with John O'Keefe. So how did we end up here? How does Karen Reed end up sitting in that chair on trial for an event that literally never happened? Well, the evidence is going to explain it. And it can be summed up in the following text message at the very beginning of this investigation. A text message of a now fired Massachusetts State Police officer named Michael Proctor. He was the lead investigator on this case, and he was talking about a fellow officer, a fellow cop, who owned the property where John O'Keefe's body was found. Text message with a buddy. Question: is the homeowner going to catch any shit? Answer: nope. He's a Boston cop too. That quote defines the lack of integrity of the Commonwealth's entire case, its entire investigation, and this prosecution. During the course of this trial, you'll learn much more about Mr. Proctor, why he said that, and what it really means. What you'll see and hear in this courtroom in the coming weeks is not just a story of a tragic loss. And make no mistake, John O'Keefe's death is and was a tragic loss. But the story you'll hear is about an investigation that was riddled with errors from the beginning, a rush to judgment, conflicted and corrupted from the start. Corrupted by bias, corrupted by incompetence, and corrupted by deceit. Finally, it was corrupted by a deliberate effort to avoid and to cover up the very truth that you are seeking. You'll find when you hear the evidence that the Commonwealth's case is the literal definition of reasonable doubt. They won't be able to talk their way out of it. They won't be able to explain their way out of it. They won't be able to excuse their way out of it. And they can't meet their extreme burden of proof, which the court will tell you is beyond any and all reasonable doubt and to a moral certainty. Members of the jury, Karen Reed found John O'Keefe dead on the front lawn of a Boston police officer, Brian Albert, at 6 a.m. on January 29th, 2022. Picture the scene. Blood-curdling screams, ambulances, emergency lights on, fire engines, ladder trucks, paramedics, patrol vehicles, patrol cruisers, police officers, first responders, firefighters, all swarming all over Brian Albert's lawn, literally feet under his bedroom window. Yet Brian Albert, a sworn peace officer, a first responder himself, never came outside. Never went outside to see what the chaos was about, never went outside to see if he could assist a man in need, never walked outside his house to see if he could help a fallen fellow officer on his own front lawn. More shockingly, you'll learn that lead investigator for the Massachusetts Police, Michael Proctor, never set foot inside Brian Albert's house that day. Never engaged in any investigation inside that house that day, even though a party with much alcohol had just occurred in that house, and even though a Boston police officer was found dead or dying just mere feet from the front door on that lawn. He never secured the crime scene, never separated and secured witnesses. He never properly collected evidence. He never secured the evidence. He never searched for signs of a struggle inside or outside the home. He never properly canvassed the neighborhood. Michael Proctor never did any of these things, even though fellow officers of Michael Proctor's actually mentioned, in their words, not mine, that it looked like John O'Keefe may have been, quote, in a fight. You'll have questions about that conduct. During the course of this trial, you'll find that the Commonwealth will not have answers. You'll see from the evidence in this case that this case carries a malignancy, one that is spread through the investigation, it's spread through the prosecution from the very start, from the jump. A cancer that cannot be cut out, a cancer that cannot be cured. And that cancer has a name. And his name is Michael Proctor. Now, you didn't hear his name in the prosecution's opening statement. Not once. And I suspect that was probably by design. But make no mistake about it. The evidence will show in this case that Michael Proctor is the very definition of the Commonwealth's case. And he's also their Achilles heel. He was the lead investigator on the case officer, the architect of the entire prosecution. You'll learn there's not a single part of this case, folks, not a single part, that he didn't touch, that he didn't direct, that he didn't orchestrate personally. Every single bit of it has his fingerprints on it. You'll learn that Michael Proctor was a longtime family friend of the Alberts. And he's been disgraced by his own agency, not by us, by the Massachusetts State Police. Investigated, suspended, and fired. The evidence will show that Massachusetts State Police found him guilty, found Michael Proctor guilty of bringing dishonor to the department for his conduct, not in some other case, not in some tangential case, in this case. The investigation of Karen Reed. Conduct that included bias in favor of his friends, the all-powerful Albert family, and bias against my client, Miss Reed, the outsider. Do you have any idea how hard it is for a state trooper to get fired? Well, the evidence is going to show that Michael Proctor earned it. Every bit of it. You'll hear that within hours of a Boston police officer being found dead on Brian Albert's lawn, Michael Proctor, the lead investigator, who had investigated exactly nothing up to this point, right at the beginning, made an early pronouncement that Brian Albert himself was not going to, quote, catch any shit, end quote. And that was for one reason, and one reason only. He's a Boston cop. The evidence will show that Michael Proctor made this statement in a text conversation with his high school buddies. A text he never thought would see the light of day, certainly never thought we would get a hold of. And when he thought no one was looking, he actually said the quiet part out loud. He's a cop too. We'll give him a pass. You'll learn that in Michael Proctor's world, rank has its privileges. And the evidence will show that's privileges that you don't get and I don't get. But apparently a Boston police officer, Brian Albert, and his friends, they do get. You'll learn that in Michael Proctor's world, he didn't care about finding the truth. In his world, his priority was to protect the brotherhood, to protect that blue wall, to protect his friends who were at the Alberts' house that night. I want to take a step back, if I could, and spend the next few minutes talking a little bit more detail about what the actual facts in this case will show, not based on speculation, not based on surmise, not based on guesswork or conjecture, but the actual true facts that you will learn through the course of this trial. On January 28th, 2022, it was a Friday night. John and Karen had made plans to meet up with friends for drinks. It was a happy and normal night for them. They were affectionate, they were loving, they were in good spirits, nothing out of the ordinary. They started at a local watering hole called C.F. McCarthy's. You've heard that name before and you'll hear it again. And eventually they made their way over to the Waterfall Bar and Grill, another bar where they ended up. When they got to the Waterfall Bar and Grill, the Albert family was already there, already heavily drinking. You'll learn that this was no ordinary family, the Alberts. The Albert family was a well-known Canton family. Some might even describe them as a very powerful Canton family. Brian Albert was there at the waterfall. You'll hear that he's a longtime Boston police officer. His wife, Nicole Albert, was there with him. His brother, Chris Albert, a powerful Canton politician. He sits on the select board. The select board actually governs the police department, the Canton PD. He was there. His wife, Julie Albert, was there. Their daughter, Caitlin Albert, was there. His sister-in-law, Jennifer McCabe, was there. Her husband, Matt McCabe, was also there. They were all there drinking before John and before Karen ever arrived. You'll learn that a man by the name of Brian Higgins, also a law enforcement officer and longtime friend, longtime pal of Brian Albert, he was also there. And the two of them, the two Brians, had been drinking most of the night together. You'll see video footage from the waterfall, which will show you that Karen and John were happy. They were affectionate. They were caring. They were loving. Just business as usual, out on a date on a Friday night. But that exact same video footage which lead investigator Michael Proctor plainly chose to ignore that video footage. It paints a very different picture of Brian Higgins. You'll learn that Higgins had romantic designs for Karen. That becomes important. Brian Higgins had engaged Karen in flirtatious texts, but days earlier she had put a stop to it. She had ghosted him, in common parlance. In other words, just ignored him. The evidence will show that the first time he saw her and was in her presence after being rejected by her was when she walked into the Waterfall Bar and Grill along with her boyfriend, John O'Keefe. At 11:58 p.m., just minutes before John ultimately arrived at the Albert residence, you'll see a video at the waterfall of an unsettling interaction, troubling interaction between Brian Higgins and John O'Keefe. And unlike the lead investigator, Michael Proctor, in this case, you won't ignore that evidence. As the bar was closing around 12 midnight, the Alberts invited everybody back to their house for a get-together to just keep the night going. And you'll learn that Karen and John ultimately pulled up to the house They got out of the SUV to make sure they had the right address. You see, neither John nor Karen had ever been to 34 Fairview. They weren't even sure they were at the right address. And the evidence will establish that John got out of the SUV and went into the house. Let me say that again. The facts unequivocally, the data, the science, the witnesses will all unequivocally establish that John O'Keefe went into the Albert home that night. Eyewitnesses and forensic data will establish that fact. When he didn't come back out, you'll learn that Karen grew increasingly frustrated. She got upset. She was left alone in a car, in the cold, in the middle of the night, with the car idling. John had gone into the house. She expected him to come right back out, and when he didn't, seconds turned into minutes, and minutes started to clock away. She left John a voicemail, then another voicemail, voicemail after voicemail after voicemail, text messages. But he was unresponsive. He didn't pick up a single call. He didn't respond to a single text. The longer he didn't respond, the more upset she got. The Commonwealth will intimate, as they already have in their opening statement, that these voicemails are evidence that the two were fighting. The actual evidence in this case, however, will show the exact opposite. You'll hear that Karen was very agitated. You'll hear some voicemails where she's swearing. You'll hear voicemails where she calls him names. There's name calling. But you'll also hear the context of those voicemails. And every single one of them, every single one of those voicemails was left for John after he failed to come back out of the house, after he failed to respond to her voicemails and to her texts. Karen believed John had just left her sitting there, grabbed a beer, was partying with his friends. The evidence will actually show that John and Karen never had a crossword, not a single crossword that entire evening before he left that SUV and went inside the house. And you will learn what Karen had absolutely no way of knowing at the time. It wasn't that he wouldn't respond to her. It's that he couldn't respond to her. And the evidence will show you why. Let's talk about that. We'll introduce you to a doctor named Elizabeth Loposada, a renowned forensic pathologist, a medical examiner, and a professor at Brown University. She will tell you that the injury to the back of John's head, first of all, was immediately incapacitating. And that has meaning. At the moment he suffered that fatal head injury, he couldn't walk, talk, grab his phone, cry for help, nothing. He was completely incapacitated, completely unconscious from the moment he suffered that injury. He was completely still and incapable of interacting with anyone or anything. But the doctor will tell you something more, and just as important. She'll tell you that John O'Keefe did not suffer from hypothermia, as the Commonwealth will undoubtedly allege. His body showed no signs of it. No frostbite, no cold-induced injuries to his organs, no damage based on cold or frost. Ladies and gentlemen, the scientific evidence and the medical evidence will establish that John O'Keefe had to be injured somewhere else, somewhere warmer, and his body had to have been moved out into the cold. And that's where, ultimately at 6 a.m., Karen found him the next morning. You will learn that John did not have a single injury consistent with being hit by a car. Let me say that again. The evidence will establish that John did not suffer a single injury on his body consistent with having been hit by a car. Not one. You'll learn that John's torso, his ribs, his chest, his arms, his hips, his legs, his knees, his ankles, his feet, all of them, no broken bones, no fractures, no contusions, no torn ligaments, no internal injuries, not even a bruise. Nothing consistent with a car accident, despite the Commonwealth's contention that he was slammed into by a 6,000-pound SUV. Not a bruise. Dr. LaPosada will tell you with medical certainty that, in fact, John was not struck by a vehicle. Medically and scientifically, he could not have been struck by a vehicle. Therefore, as I said, there was no collision. She will tell you that the patterned abrasions on John's right arm, the patterned abrasions you see over my left shoulder, they're not the result of being struck by a car or a taillight. You'll take one look at these injuries and you'll agree with Dr. LaPosada. The evidence will show that these injuries are from an animal, like a large dog, like the large dog that was inside the Albert house that night. You'll learn that Brian Albert has actually admitted that his large dog, the family dog, is, quote, not good with strangers. And of course, John, never having been to the house before, was a stranger that night. You'll also learn that oddly, very oddly, after having their family pet for 7 years, a short time after this incident, the Alberts got rid of that dog. They called it rehoming her. But she was gone. Dr. LaPosada will also tell you that the injury to John's head was not the result of falling backward onto a flat lawn, cold or otherwise. Rather, Dr. LaPosada will tell you with medical certainty that the injury pattern to his scalp was produced by an impact from a raised or ledged surface, a surface that does not exist on Brian Albert's front lawn where John was found. The medical evidence will establish no hypothermia, no injuries from a car strike, no collision with a motor vehicle. And forensic analysis of John's cell phone, Mr. Brennan mentioned that in his opening statement. The Commonwealth's own expert will ultimately support the exact facts that I just told you, including the temperature data. John O'Keefe was injured someplace warmer, and he was moved. That alone is reasonable doubt, but there's much more. You'll also learn that there were many people at that after-hours gathering at Brian Albert's house who would have left by the front door just feet from where John O'Keefe's body would have ultimately been, had he actually been there, right after 12:30 a.m., which is what the Commonwealth's claim is. There were nearly a dozen people who walked out that front door directly adjacent to the precise spot where John O'Keefe would have been lying. Not a single person, not one, not a single person, saw a 6'2", 216-pound man laying sprawled in the front lawn in dark clothing on a light white dusting of snow. Not one. Then the evidence will also show that every one of those same people drove by that same spot, not walked by it, drove by it to leave the house, and still not one of them saw John laying in the yard when they left between 1 a.m. and 2 a.m. in the morning. But you know who else you'll find never saw a body on that lawn? The snowplow driver, a completely independent witness charged with plowing the streets in Canton that night. You'll hear that Michael Proctor, oh, he's not done yet, Mr. Proctor. You'll hear that Michael Proctor wrote a report where he claimed that Fairview had not been plowed that night. You'll learn that that was completely false. That was a lie. Michael Proctor did not want any more witnesses. He didn't want the truth, and he falsely claimed that the road was never plowed. You'll learn that he wouldn't look for the plow driver, but we did, and we found and will introduce you to Brian Loughran. He plowed Fairview that night, and what he's going to tell you is that there was no body on that lawn at 2:30 in the morning. You'll learn that Brian Loughran passed by 34 Fairview, traveling right next to Brian Albert's front yard, and at 2:30 a.m., John O'Keefe was not there. But you'll see that the plow driver also provides some other troubling information, troubling testimony for the Commonwealth. You'll learn that after making that pass at 2:30 a.m., he showed up with his plow an hour later. He stopped at the entrance of Fairview. He was looking up Fairview to decide whether or not to plow it, but he saw an obstruction. At 3:30 a.m., he looked down the street, and in the very spot the very spot precisely where Karen would later find John's body laying at 6 a.m., there was a car parked in front of it, a Ford Edge. You're going to ask yourself, who's moving a car at 3:30 in the morning into a blizzard on the side of the road? You'll learn that Michael Proctor, the lead investigator, intentionally ignored this fact as well. He did no investigation to find out who owned a Ford Edge, but again, we did. And the evidence will establish that a Ford Edge happens to be a favorite model of the Albert family. More than one Albert owned a Ford Edge at the time. You'll learn that those facts will add to the mounting and the overwhelming evidence that there was no collision and John O'Keefe's body was moved onto that lawn. You'll find that this is yet additional reasonable doubt in the case. You'll be introduced to science and physics, even from the Commonwealth's own experts. That science will establish that Karen Reed's SUV was not damaged by hitting a pedestrian, and conversely, John O'Keefe's injuries did not come from being struck by a vehicle. The Commonwealth mentioned triggering events, but what you'll actually learn from the experts, some of them the Commonwealth's own experts, is that a triggering event is not evidence of an accident. It does not evidence a collision. That's why we're here. A collision. And there's no evidence of one. Zero. You'll also find that those exact sort of triggering events that the Commonwealth will rely on are relatively commonplace on Karen's SUV, and none of them are associated with a claim of a collision. Folks, the science will not lie, and the physics cannot lie. And that science will tell you with certainty there was no collision with John O'Keefe. You'll add that to that rising mountain of reasonable doubt. I want to take you back to the night in question, January 29th, for just a few minutes. Remember, Karen had gone home after dropping off John and John walking to the house. While Karen was asleep at home with John's 13-year-old niece, what were the people who had been at Brian Albert's house that night? What were they doing? While she slept, what you'll find and what the evidence will show is that they were extremely busy. You'll learn that after a long night of heavy drinking, Brian Higgins left the Albert residence, but he didn't drive home. Rather, he drove over to the Canton Police Department, where he kept an office at about 1:25 a.m. Not a Canton police officer, but he kept an office there. Why go back to his office at 1:25 a.m.? Why go back to the Canton Police Department at 1:25 in the morning on the night of a blizzard? You'll learn that while there, Higgins made a call at 1:30 a.m. Higgins will later deny that he made that call. You'll find that curious. And his explanation for that late-night visit to Canton PD, you'll find that it changes nearly every time he's asked about it. You'll learn that after everyone left Brian Albert's house, Brian Albert actually claimed he had no contact with anybody else except his wife. No contact. Until he woke up the next morning. So he says. Then you'll learn that that, too, is a complete lie. His phone records establish that he placed a call to none other than Brian Higgins at 2:22 a.m., shortly after Higgins completed that late-night visit over to Canton PD. You'll wonder, what did they possibly need to talk about at 2:22 a.m. that night? The evidence will establish that Brian Albert called Brian Higgins first. Brian Albert then disconnected that call when Higgins didn't answer it. Seconds later, Brian Higgins returned the call. Brian Albert then did answer that call. They spoke for 22 full seconds, had a conversation, then they both hung up their respective phones. You'll learn that when they were asked about these calls and conversations, both Brian Albert and Brian Higgins lied about it. Both of them. They said they never had a call with each other. But then ultimately, when they were confronted with their own cell phone records and they could no longer deny the calls, they were asked independently, explain yourself. And they both came up with the exact same explanation. A butt dial. The evidence will make you question, why did Albert and Higgins speak at 2:22 a.m. and why did they both try to cover up that phone call? You'll also learn after this incident and within days of one another, both Brian Higgins and Brian Albert, both police officers, both trained investigators, got rid of their phones. Both of them. And what else you'll learn Brian Albert got rid of? Shortly after this incident, Brian Albert got rid of his house, the whole thing. Just sold it. His childhood home, a home that had been in the Albert family for generations, he literally sold it mere months after this incident. Dog rehomed, phones destroyed, house sold. You'll learn that all these things happened shortly after the incident where John O'Keefe was found unresponsive and dying in Brian Albert's front lawn. And you'll also learn that Michael Proctor looked the other way. He did not investigate any of what I'm telling you. He pre-selected Karen Reed from the start, and he ignored everything and everyone else. Let's get back to what was happening with the others while Karen slept. What you'll learn during this trial is that Brian Albert's sister-in-law, you've heard her name before, Jennifer McCabe, she was at the waterfall that night and she was over at the Alberts' house that evening as well. She left the after-hours gathering about 2 a.m., a little before 2 a.m., got home around 2 a.m. And you'll learn that according to the Commonwealth's own evidence from a forensic software program called Physical Analyzer made by Celebrite, it's considered the gold standard for forensic tools. You'll learn that a Google search was discovered on Jennifer McCabe's phone. A Google search that Michael Proctor and his investigators never revealed to us, but we found anyway. A Google search that was time-stamped, according to their own data, at 2:27 a.m. 5 minutes after that 2:22 a.m. call that Higgins and Albert denied having. And that Google search on Jennifer McCabe's phone read, "Hoslong to die in cold." Hoslong to die in cold. Now, she misspelled the first word. Hos is supposed to be how, but the meaning's the same. How long does it take to die in the cold? Time-stamped 2:27. And then that search was also noted by the same Celebrite program as having been deleted. The evidence will force you to ask, why is there a search on her phone? Why is it logged at 2:27 a.m.? When the Commonwealth claims that she first learned of John's death and where his body was hours later at 6 a.m. So what you'll learn is that while Karen slept, here's what was actually happening by some other very busy bees. 1:25 a.m., Brian Higgins makes an unexpected visit to Canton PD. 1:30 a.m., he makes a phone call that he later denies ever making. At 2:22 a.m., Brian Higgins and Brian Albert talk. They both deny and lie about having made that phone call. 2:27 a.m., 5 minutes later, a Google search appears on Jennifer McCabe's phone, Hoslong to die in cold, hours before John's body was ever discovered. A Google search she denies making, and that she later, or at least it was later logged as deleted. Meanwhile, at 2:30 a.m., the plow driver confirms that O'Keefe's body was not on the lawn of Brian Albert's house, not at 2:30 in the morning. And at 3:30 in the morning, that area was obstructed by a Ford Edge like the one the Albert family liked to own. The evidence will show in the meantime, Karen dozed in and out of a fitful sleep for the rest of the night, only to awaken just before 5 a.m., and that's when she realized, in a panic, John had never come home. And you'll see, it wasn't like John to not come home. That morning, you'll see and hear evidence that Karen's emotions had morphed. It'd gone from frustration and anger, which you'll hear in the voicemails, to abject fear. Fear that something bad had happened. The evidence will establish by this time Karen was panic-stricken. She had a feeling something was very, very wrong. She was unable to get a hold of John. Karen went to go look for him. She got in her Lexus, and she backed up to leave her garage at One Meadows. You'll hear a lot about that address, One Meadows. That was John's house, where Karen was staying. She backed out of the garage, and during the course of the trial, you'll hear that she actually struck another car with that right rear taillight. During the course of this trial, the Commonwealth is going to desperately claim that Karen Reed's taillight was actually damaged by hitting John O'Keefe. They'll have no evidence of it, mind you, none, but they'll make the claim. We'll show you a video of exactly how that taillight was originally damaged, or exactly what happened at 5:07 in the morning. The facts will show that it was damaged in John's own driveway at 5:07 when Karen backed up and made contact with another car in the driveway. This is 5 hours after she dropped John off and he went into the Albert residence. As a result, the taillight was minimally cracked, but it wasn't completely shattered or damaged or broken. And that's the condition of the SUV when Michael Proctor got a hold of it. That becomes important. You'll hear from an independent police officer, an eyewitness to the damage on that SUV, someone not connected to Michael Proctor or under his control. And he'll tell you that he saw the taillight damaged before it was in Michael Proctor's possession, but it was not completely shattered. And you won't have to speculate how that taillight got cracked originally. You'll see it for yourself. It's on video. You'll learn that part of the reason that Karen's Lexus hit that car at One Meadows is because she backed out looking for him at a time when she was absolutely panic-stricken and grief-stricken. Where was John? Why hadn't he come home? What had happened to him? Is he hurt? Is he passed out somewhere? Her mind was reeling. The evidence will establish she wasn't giving anything away. Everything was on the table. What could have happened to John? You'll learn that when she woke up and he still wasn't home, she was just racking her brain for what could have happened to him, and she was worried about possibly the worst. He had gotten out of the car, he'd walked to the house, she was confused, and later, when she found him at 6 a.m. on the lawn, where she last saw him going toward the house, her mind started reeling, oh my God, did a plow hit him? Did I hit him? Could I have hit him? What could have happened to him? And that video clip that you saw, out of context, when she said the words, he did not look like he was mortally wounded, she's not talking about at midnight. She's talking about at 6 a.m. when she found him. That's what she was talking about. Your job will be to make sure that the evidence isn't presented to you too cute by half. She was saying all those things. Did a plow hit him? Could I have hit him? Did I hit him? She was saying that to herself and to other people. And the Commonwealth, very obviously, will try to seize on that panic and twist this into some admission. But here's the actual truth. That's not a confession. Could I have hit him? Did I hit him? Could a plow have hit him? That's a person trying to make sense of an unexplainable circumstance, a natural concern of a bereaved significant other, a woman desperately trying to piece together what could have happened on this tragic night. John didn't come home. And the evidence will show that Karen Reed never said, I hit him. Never. Not in the background of the 911 recording, not on any dash cam video, not on any audio, not on any police body cam, not to a first responder. It's never mentioned in a single report. It's never reported in a single report from January 29th, not by one person, because it never happened. The evidence will show that there were at least 13 members of law enforcement or first responders and 2 civilian witnesses that were intently focused on what was happening at that scene. They were all over the lawn. They were all over Karen. Officer Seraph, Mullaney, Good, Lank, EMT Nuttall, Flamati, Kelly, Walsh, Woodbury, Whitley, Becker, Robery, McLaughlin, Carrie Roberts, Jennifer McCabe. They were all there, watching and listening. On January 29th, when John O'Keefe was found, not one first responder reported having heard Karen Reed say the words, I hit him. Not one. Not one civilian reported having heard Karen Reed say, I hit him. The facts will show that the first time this improved statement was ever claimed to have been made was some 24 hours later by a single EMT in an interview, now listen to this, in an interview coordinated by a Canton police detective named Kevin Albert, Brian Albert's brother. And remember, Chris Albert, the other brother, is a board selectman to whom the Canton Police Department reports. And what's more, you'll learn that Katie McLaughlin, that's the EMT, that's the single EMT, the first person to have claimed to have heard this unrecorded and unreported statement, is years-long, close personal friends with a young woman named Caitlin Albert. You heard that right. It's Brian Albert's daughter. During the course of this trial, you'll become familiar with and you'll realize that the Alberts are indeed a powerful and indeed an influential family, and that will mean something. You'll learn that there are other major problems with the prosecution's case. The evidence will establish that Michael Proctor himself, the lead investigator and architect of this entire case, has a long-standing and personal relationship with the Albert family. Yes, that same Albert family. His sister was close friends with Julie Albert. He personally sat at head tables at weddings, or at a head table at weddings with the Albert family. He entrusted the Alberts with babysitting his own children. You heard that correctly. And yet he was the lead detective assigned to investigate the circumstances of a Boston police officer laying dead on the Alberts' front lawn. That's not just bias, you'll learn. That's not just coincidence. That, folks, is corruption. And you'll see how far it went. Michael Proctor was alone with all the critical evidence in this case, alone with Karen Reed's phone, alone with John's phone, alone with video footage, alone with the taillight material, alone when he claimed to recover evidence from 34 Fairview. He wrote the search warrants, he transported the evidence, he secured it, he submitted it, he did it all. That's Michael Proctor. And he did it without any reasonable oversight. You'll see during the trial that he intentionally lied and fabricated evidence during the course of this investigation. He lied in reports, warrants, he lied under oath. He lied about the time that he actually secured Karen Reed's vehicle. Why? Why would he lie about that? The evidence will give you the answer. He lied because he did not want it revealed that he had access to that vehicle and he had access to that taillight before any taillight fragments were found at 34 Fairview. Appreciate that. He had access to the vehicle before a single piece of taillight material was ever found at the scene. You'll find that there were two searches. The first and second search found zero, nothing. Nothing around John's body, nothing in the street, not one piece of taillight fragment. But once Michael Proctor had that SUV and had the taillight in his custody and control, suddenly items started magically showing up. And not just a few items, 46 pieces of bright red taillight laying in the snow, supposedly found in the exact same spot that was searched not once, but twice by independent officers. It came up with zero. To be clear, you'll learn that before Michael Proctor had access to that taillight, not a single piece was ever recovered at 34 Fairview. That will become vitally, vitally important. And what about those shards of plastic, by the way? What about this DNA that the Commonwealth mentioned? They're going to try to dazzle you with talk of DNA because it sounds so scientific. DNA was on the taillight. But you'll learn that there was no DNA on the actual shards that they claim came in contact with John's arm. None. There was no blood, no tissue, no skin, no DNA on a single shard of plastic that they claim cut deep abrasions into John's arm, the arm that you saw overhead. The DNA that was actually found, the actual science will show, was found outside of the taillight housing where anyone with access to that vehicle would have touched. And it wasn't just one male's DNA. In that exact same sample, there were 3 men found, John and 2 unidentified males. So unless the Commonwealth is going to shift their theory that that SUV hit 3 men that night, their entire theory falls apart. And speaking of DNA, the evidence will further establish that John O'Keefe's shoe, the one that he was wearing when he was found, was sampled. And that DNA revealed 5, count them, 5 unidentified males. Recall that the evidence will establish independently that John was injured someplace warmer and had to be moved onto that lawn. 5 unidentified males touching that shoe. You'll also learn that you are not the first person, not the first to hear about the Commonwealth's theory of this case, that John was hit by an SUV. That's their theory. The Commonwealth presented this exact same claim to their own medical examiner, a woman by the name of Dr. Irini Scorti-Bello. And you'll learn that after reviewing what's called a law enforcement accident notifier, with law enforcement's theory of the collision written in it, defined in it, after conducting the autopsy herself, after examining John's injuries in detail, she refused to conclude that John's death was a homicide based on the Commonwealth's presentation and their theory. That's right. The Commonwealth's own medical examiner will not deem the manner of death in this case, a homicide. She won't do it. But they're nonetheless back again trying to present the exact same theory to you in this trial. Again, the evidence will show that that is reasonable doubt. Throughout this trial, the Commonwealth will try to convince you of paranormal events, phones calling themselves, messages deleting themselves, Google searches made and then unmade, evidence magically appearing and evidence magically disappearing. But all that smoke and all those mirrors will not ever reach their burden. Because that's what this case is ultimately about. It's about the Commonwealth's burden of proof. You'll learn that during the trial, the Commonwealth bears the highest burden known to our justice system. They must prove every element of every charge beyond a reasonable doubt and to a moral certainty. And you'll learn that moral certainty means the highest level of certainty known in human affairs. It's not a small thing. They're not going to be able to do that. Not when every piece of this case was handled by a disgraced investigator with a motive to protect his friends, not when the physical evidence contradicts their very theory, not when their own medical examiner won't call this case a homicide based on the exact theory that they're presenting to you, not when the conduct of those in the house and the utter lack of investigation speaks volumes about those who actually have something to hide. By the end of this trial, you'll conclude that Karen Reed is not guilty of hitting John O'Keefe with her SUV. There was no collision. She's the victim of a botched and biased and corrupted investigation that was never about the truth, folks. It was about preserving loyalty. You'll find that this case is the very definition of reasonable doubt. And at the end of this trial, we'll ask you to return the only verdicts, all 3 of them, that are consistent with the evidence, the science, the truth, and justice. Not guilty, not guilty, not guilty. Thank you.
Thank you, Mr. Jackson. Folks, why don't we take our morning recess?
Excuse me.
All right, whenever you're ready, Mr. Brennan.
Thank you, Your Honor. Good morning.
Good morning, sir.
Could you please introduce yourself to the jury?
So my name is Timothy Nuttall. I'm 28 years old. I've been a firefighter paramedic ever since I graduated high school. I graduated in 2015. I took my EMT class and got my certification while I was actually still in high school. From there, I moved on to the BLS transfer side of EMS. There's 911 EMS, and then there's transfer, which is basically back and forth from hospital to hospital. I was brand new and very young, so I started on the transfer side, kind of learning the job. I started primarily in the city of Chelsea, Everett, Malden, Somerville, up there. And then after a little while, I got my feet wet in the 911 side. So I was running BLS 911 in those cities as well. And then I progressed on to become a paramedic. So
Why do you have such an interest in being a first responder at a young age?
I kind of grew up in a first responder household. My father was a firefighter in a local town, so we spent kind of a significant amount of time at the station when he was on shift. It's just kind of how I grew up, kind of learning the ins and outs of public safety. That's just kind of how I came to be interested in the profession, and then I took it from there. So
I want to take us back just a little bit. When you first became interested in training to be a first responder, did you share with us your first training was as an EMT?
yes, sir.
Can you share a little bit with the jury what that entails?
So to become an EMT, there are two sides of EMS, and then there are two sides of providers. There's EMT basic, and then there's paramedic. To answer your question, sir, to start as an EMT, it's about a 4-month process. You take classes. I believe mine was Tuesday, Thursday, every other Saturday. Learning just anatomy and physiology, basic pharmacology, and kind of how medications interact with the body and different disease processes. From there, you start learning basic interventions, backboarding, C-collars.
As part of your work in learning to be an EMT, are you active in the field?
The initial training is, like I said, that's mostly classroom-based, but once you sit your national written test and you're able to pass all that and pass practical, then you're able to progress into the field.
And did you succeed through the EMT training?
Yes, sir.
At that point, did you decide you wanted more training? You want to proceed through the profession?
Yes, sir. So after a little while, I worked for about a year and a half in the field and decided that I genuinely enjoyed the work that I was doing. I then made the decision to progress to the paramedic level. That's a significantly more challenging academic portion. And
Can you briefly share with us a little bit of the training that you needed to complete to be a paramedic?
yes,
And how
paramedic training is about, I would say, generally takes people about 2 years to complete. There's about 1 year of classroom. It delves far deeper into not only diseases, but how they interact with multiple body systems, multiple different treatment modalities that we can pursue, multiple different interventions, a whole host of medications, far more medications than a BLS. As a paramedic, I have a much wider range of drugs that I would be able to select to treat different patients.
As you worked through your training and got this experience, did you ultimately become employed by the Canton Fire Department?
Yes, sir.
What did they hire you as?
They hired me as a firefighter paramedic.
And so you were both a firefighter and a paramedic.
Yes, sir.
Does the Canton Police Department, in their units, do they include paramedics and firefighters in the same division?
The Canton Police Department or the
I
Canton
mean,
Fire?
I'm sorry, the Canton Fire Department.
Canton Fire Department, the vast majority of the employees of the Canton Fire Department are paramedics. I believe there are I want to say 5 EMTs, but now as a requirement to remain employed by the Canton Fire Department, you have to become and maintain a paramedic certification.
So when you would go to work as a firefighter or paramedic, was it always the same, or did you get assigned as a firefighter one night and a paramedic a different night?
So we would cross-man trucks. We were always fire suppression personnel, but we were also cross-trained as paramedics. So for example, if a fire call were to come in the town of Canton, and I was assigned to Ambulance 1 for the day, I would take all my equipment off Ambulance 1, and I would transfer it to Ladder 1, and then we would take Ladder 1 to the fire call and operate as fire suppression personnel. If a medical call were to come in, I'm assigned again to Ambulance 1, then we take on the role as EMS. I take my paramedic skills and put them to work in the town on Ambulance 1.
Let me ask you one more background question about how the Canton Fire Department works. When there's a call, an emergency call, is an ambulance sent with other vehicles or alone to the call?
Yes, sir. It's typically an engine, the engine of that district, and the ambulance of that district. Depending on call volume, that can change. But if all is not to use the word quiet, it's kind of a taboo word, but if all is everybody's in quarters, and there's a dispatch in District 1, it'll be Canton Engine 3 and Canton Ambulance 1, and they go as a unit together.
Mr. Nuttall, I want you to take us back, if you would, to the early morning hours of January 22nd, 2022. I want you to bring us a little bit before 6 a.m. Do you remember what you were doing?
Yes, sir. So that particular morning, I arrived at work earlier than I normally do. There was inclement weather that morning, so I left earlier than normal just to get in before the roadways got particularly difficult to travel and to relieve anybody that may need to get out if they needed to get home before the roads got particularly bad. I arrived just before 6 a.m. I was walking in. I was assigned to ambulance 1 for that oncoming 24. I was scheduled to be there at 8 a.m.
Could you share with us a little bit about how the weather was as you arrived around 6 a.m.?
It wasn't great. I was driving. It's about a 35-minute ride for me to get to Canton. The roads were starting to get. They weren't great. They had been treated, but they weren't pristine. The wind was starting to pick up. The snow was starting to come down a little heavier, which is the reason that I left at the time I did.
And so I may have misspoke. January 29th, 2022, that morning, around 6:04, did you hear a tone or did you hear an alarm?
So the tones went off right as I entered the building.
Tell us what a tone is.
So the tone is the emergency alert tone. In the town of Canton, we have 3. We have 1 for fire, we have 1 for investigation, and we have 1 for EMS. The EMS tones went off and the lights came on. Whenever there's the tones go off, the lights come on as well. I was just walking into the building when the tones went off and the lights came on.
And is there information that accompanies the tone, information about the call that needs response?
Yes. So after the tones had cleared, there's an overhead dispatch, which is our dispatch center, communicates to us before we get in the trucks and on the air responding. Basic nature of the call. In that particular instance, we were dispatched to an unresponsive male in a snowbank with no real further information to follow up on.
So what do you do?
So as I said, I arrived pretty early that morning. But hearing that dispatch and that nature of the call, those typically tend to be more involved, both personnel-wise and work-wise. The crew that was working that morning was getting on the truck, and it was firefighter paramedic Anthony Flamati and firefighter EMT Matt Kelly. Matt Kelly has since become a paramedic, but at the time he was an EMT. So off the bat, that crew, not to say that they were at a disadvantage, but paramedic Flamati was the only paramedic on that ambulance.
What did you do?
So I made the decision. I checked with the shift commander, and I jumped on ambulance 1 to just give a second set of hands as being a paramedic myself, just being able to hopefully help if there was any advanced interventions that needed to be done or needed to be performed.
What happened?
And just a second set of hands.
What happens next?
So I got in the back of the truck. I was actually still in civilian clothing at the time because I had just walked in the door. So I got in the back of ambulance 1 in the patient compartment. The other 2 gentlemen were up front driving to the scene. I actually had to don my turnout gear because, again, I was in civilian clothing. I wasn't quite ready to go. So I had to put all my structural turnout gear on and then my Canton Fire jacket. Once I was sufficiently dressed for the call, I started prepping all the gear that we might need for a call such as that, for an unresponsive male in the snow. In this case, it was our first in bag, our airway bag, and our cardiac monitor. Everything was all together. They were all in 3 separate bags. But on the way there, I just got in. I didn't know how their night had gone, so I just took a real quick look at everything just to make sure everything was there and everything was exactly how it needed to be. So I was able to just grab all 3 bags, put them on my person, and get ready to, so as soon as the ambulance was on scene, just step off and go to work.
Not knowing much information about what you're going to confront, what goes through your mind as you prepare before you get off the ambulance?
Just basic scenarios. I mean, again, unresponsive male in the snow could mean several things. Not having much to go off on the dispatch was, it left much to be desired in terms of what we might need. So in gathering all the equipment together, that can kind of cover all the major bases, if you will, in terms of what we were expecting to meet once we got on scene.
How was your focus before you get off the ambulance?
I was ready to go. A dispatch like that, any unresponsive male in the snow, it can kind of up the level because you just don't know what you're walking into. You know, it could be anything.
In the back of the ambulance, you can't see outside. Could you tell anything about the weather conditions based on the way the ambulance was moving?
Again, being in the back, as you noted, it just seemed to be taking a little bit longer than normal. I really had no visibility at all. Like I said, I was in the patient compartment. It's very limited visibility in the back, and it's limited visibility. There's like a peephole that's maybe 1.5 by 1.5 to kind of peek up front. But again, I was so busy getting everything together, I really didn't notice, but I did note it took a little bit longer. We were going not slow, but we were going cautiously.
When the ambulance finally stopped and the doors opened, tell the jury what you see.
So as I mentioned, I had the 2 bags and the cardiac monitor, so 3 pieces of equipment with me. And I stepped out of the back of the side of the truck. There's a back compartment, or a back door, and a side door. I stepped out of the side door. And I immediately noted the wind had picked up and the snow seemed to be heavier. And I could hear like a distant screaming off in the distance. Wasn't exactly sure where it was coming from.
What was the visibility like?
It wasn't great. It was still dark out. The sun had not come up yet. The snow was coming down, as I said, heavily. And it wasn't great all around.
Was it cold?
It was cold. Yes, sir.
And so when you hear the screams, what do you do next?
I started making my way kind of towards the sound, following the sounds. I couldn't see anybody yet. So I just kind of followed the sounds. And then once I was able to get around the side of the truck, that's when I was able to see a group of 3 individuals with Canton Police. And I started making my way over to them to see where the patient might be located and what was going on.
As you get closer, tell us what you see.
So as we approached the scene, as I said, there were 3 individuals, and Canton Police were on scene as well. And then there was what appeared to be a human figure laying supine in the snow. I'd say about 6 to 8 feet, kind of where the sidewalk met the front lawn of a residence.
What does supine mean?
So that he was laying on his back.
Okay.
From there, I made my way directly over to that individual and started checking for signs of life.
How do you check? Do you get close? Do you get down on the ground?
Yep, so I knelt right at his head. Typically, to check for any signs of life, it's just as you see in TV or anything like that. You check the carotid pulse, and you check for any signs of breathing or anything like that.
Where's the carotid pulse?
So the carotid pulse would be right in the neck. Like and just real quick, 2 seconds, you can check either side. They're on both sides. Those are the strongest pulses that you can grab quickly. So I just real quick went right to that gentleman. Like I said, I looked for any signs of breathing. I found none. I checked a carotid pulse, and I found none.
How was his skin to the touch?
He was very cold to the touch.
He wasn't warm?
No.
And so after you touched his cold skin and you felt the carotid artery? Is that how you
Yes,
call
sir,
it?
carotid artery.
Did you come to any initial quick assessments or conclusions in your mind?
So I found, like I said, I checked for signs of life, the carotid, the signs of breathing. I found none. From there, we had ascertained that there is no signs of life. As I was checking that, the other 2 individuals on the ambulance came and met me, and they began doing the same thing, just to check. Sometimes you can look and you can miss. So the other paramedic, Anthony Flamati, started checking my work, and then we kind of went from there. But I found no signs of life in my initial.
So firefighter paramedic Flamati arrived to this person after you did?
Yes, sir. I was the first one to actually put hands on the individual and check for signs of life.
Did you later learn the name of this man?
I did.
And what was that?
John O'Keefe.
After you found no signs of life for John O'Keefe, did you get up and go to speak to anybody?
I did. So as being a second set of hands on the call, it's really not my call, like in terms of treatment modalities and how we want to progress. So after I found no signs of life, I kind of got up to kind of look around real quick. I went over to the individuals, the three individuals that were there, and just said, hey, I just have found no signs of life. We're going to see the next steps. And as I was saying that was when Anthony Flamati, who is the lead paramedic on this, made the decision this is a workable cardiac arrest.
Let me ask you two questions. The first is, as a paramedic firefighter, are there times when you're the lead paramedic on a call?
Yes, sir.
And so it changes call by call, but this one was firefighter or paramedic Flamati's lead.
Correct. He was the lead paramedic on this call.
There are other times when you're the lead and firefighter or paramedic Flamati is on your crew and you lead?
Yes, sir. So we typically switch off. We'll do one, and then once my rotation is complete, we'll do the next one. So it's patient for patient, typically.
When firefighter paramedic Flamati called you back and said it was a workable situation, can you explain to the jury what that means?
Yes. So in medicine, there is a term that is you're not dead until you're warm and dead. Meaning your core temperature, your core body temperature has to be within normal limits for it to be considered a futile attempt at resuscitation. Noting that, Tony, the other paramedic, Tony Flamati, realized that this gentleman was very cold to the touch and that this was now a hypothermic cardiac arrest, or a cardiac arrest in a hypothermic setting, which means as providers, we have a duty to initiate life-saving measures, CPR, ventilation, and continue those efforts until we get him to a hospital and a physician is able to take over and they are able to monitor his core body temperature for a certain amount of time.
I want to ask you about a term you used. You said a hypothermic situation. As a firefighter paramedic treating a patient at the scene, you're not diagnosing hypothermia, are you?
No, sir.
So you're not making a medical diagnosis, you're just saying it's a hypothermic situation because of why?
Just because of the conditions, he was extremely cold to the touch, and he was in the elements. We didn't know how long, so taking the fact that he is extremely cold to the touch and he had been outside for an unknown amount of time, that quantifies it to us as a hypothermic arrest or a cardiac arrest in a hypothermic setting.
But is there anything about Mr. O'Keefe's fingers or hands or his face that gave you any indication if he had been there just recently or had been there for a while?
His fingers were quite cold. They were not well perfused at all. They were very,
what does that
very.
mean? I don't know. What does not perfused mean?
Sorry, did not appear to have been any blood flow at all. Just because he was, again, presumably being outside, his fingers were very, very white. They were very stiff, which can be signs of hypothermia and frostbite. And again, touching the neck. So typically, when you get cold, you kind of work back from your extremities in. So again, I noted his fingers were quite cold, but also when I checked his carotid, his neck felt quite cold as well. That just kind of tipped us back further down the road of a hypothermic cardiac arrest.
I see. When firefighter Flamati called you back,
Yep.
where did you go exactly?
So when I was told that this is what we're doing, I turned around and I went right back to where I previously knelt, which was right at Mr. O'Keefe's head. And then I took over the ventilation aspect of a cardiac arrest. So I was in charge of the airway. So I began giving him positive pressure ventilations with a bag valve mask, which is just a glorified balloon that you can push oxygen through and down into your respiratory tract to get oxygen moving. While I was doing that, I believe firefighter EMT Kelly had begun CPR.
So is this fair to say it's a team effort,
Yes, sir.
a coordinated effort?
Very much so.
And depending on where you're placed, whether in the back of the ambulance or driving or leading, does everybody have an important role to play?
Yes. Yeah, we work in conjunction with each other. Typically, the most well-defined roles in a cardiac arrest in EMS is your airway monitor, which was myself in this situation, and then your cardiac and medication administration, which is, that would be Anthony Flamati, that would be Tony. Just because of my position at the head, I just took over the ventilation aspect, and that was where I remained throughout the call.
You said you went back to try to help Mr. O'Keefe, and you were helping at the airway. Do you have to actually get on the ground to do that?
Yes, sir, I was kneeling at his head.
While you were kneeling at his head, well, let me ask you more of a background question. Is it helpful to get information about the history of the person when you're trying to treat them when you happen upon a scene and you don't know the history?
Yes, sir, very much. Getting information on medications, history, and allergies is our top priorities in any call, not even this call, just really any your run-of-the-mill fall or chest pain. Typically the first questions that we ask: what medications are you on? What medical history do you have? And do you have any allergies? The medical history is important because if you've had heart attacks in the past, or just using a generalized example, if you've had heart attacks in the past, does this feel like a previous heart attack? It kind of gives us something to go off of.
As you were nailing, I want you to take us to that moment. As you're nailing, trying to help Mr. O'Keefe, did you have a chance at any point to look up?
I did.
And when you looked up when you were trying to help Mr. O'Keefe, can you tell us who you saw?
I saw a middle-aged middle-aged female with blood on her face. And real quick, as I was in the process of providing ventilations, I said, do you know this person?
The person that you looked up and saw that was standing over you with blood on her face, do you recognize that person in this courtroom?
Yes, sir.
With the court's permission, sir, could you point out that person that you looked up and saw?
In between Mr. Jackson or next to Mr. Jackson.
I see. And when you looked up and saw that person and asked about any background, what did she say to you?
I hit him, I hit him, I hit him.
How clearly do you remember her words saying to you, I hit him, I hit him, I hit him?
I remember it very distinctly.
You've been to a lot of calls over the years and since.
Yes, sir.
Would you say hundreds or thousands?
Thousands.
Do you remember all of them?
I remember aspects of various calls, but not all of them, no.
Do some stand out more than others?
Yes, sir.
Did this particular moment stand out more as compared to your typical or most calls that you've been to?
It did, just because of the setting. I mean, it was the weather, it was the unknown factors, and it was the attempting to try and get information and not really being able to glean anything from that.
After the defendant said to you, I hit him, I hit him, I hit him, did you ask any follow-up questions?
I really didn't get a chance to, because following that, the individual just kind of walked away, or just kind of went in a different direction. I wasn't able to ask any follow-up questions.
Have you ever received any police training?
No, sir.
Are you a police officer?
No, sir.
When you're helping a patient, do you have any interest in detective work?
No, sir.
Do you have any interest in investigating potential crimes?
At that time, in this particular instance, because I was at the airway, that is a pretty critical aspect of a cardiac arrest. I was stuck there. I couldn't get up and kind of follow up on that at all. I was there doing that ventilation.
Is it your job to investigate cases, or simply to get information to help treatment?
Just the information.
When you go out as a firefighter paramedic, do you have a purposeful cause?
Yes, sir.
And what is that?
To save lives.
And is that your only focus?
In this instance, it was attempting to restore circulation and breathing.
At some point with your colleagues, did you lift Mr. O'Keefe from the ground?
We did.
When you lift him, what do you put him on?
So we put him on, it's called a scoop stretcher. It's basically just a hard plastic moving device with some seatbelts on it, just to get the patient up and onto the stretcher. And then from there, we can move from the stretcher to the ambulance.
After you lift him to the stretcher, tell us what happens next.
So we put Mr. O'Keefe on the scoop stretcher, and we were able to get him onto the stretcher itself and then off to the ambulance. From there, I maintained my role as the airway individual on this call. So we made our way to the ambulance. I got in the tech seat, which is directly behind where the stretcher locks in. So I had access to the airway again. I was continuing to provide positive pressure ventilations to Mr. O'Keefe, and we had put in an OPA as well, which is just a plastic hook, if you will. It just keeps the tongue from falling back into the airway, so we can continue to provide positive pressure ventilations. Once we got him in the truck and we continued that effort, we set up a suction system and we prepared to intubate Mr. O'Keefe. We prepared a suction system just because as I was ventilating outside of the ambulance, there were some secretions in the airway that I could see, and you could kind of hear it as you go to squeeze in breaths into the individual. You can kind of hear the secretions kind of getting like bubbly and stuff like that. So we knew we were going to need to suction him. So we got him in the truck. We really quickly suctioned him, and then we were able to intubate him successfully to definitively give him an advanced airway and give him better ventilations, get more oxygen into his system.
Now, you mentioned that he wasn't warm, he was very cold.
No, he was still very cold.
What does the team do to try to assist with that?
The most basic thing that we did, we turned the heat on as high as it would go. We also stripped all of his clothing off, just getting all of that wet clothing off of him. I didn't really have a role in that particular part of it, just because once you're on the airway, that is kind of yours. Nobody can breathe for him, so every time I squeeze that bag, he gets a breath. So I'm kind of tied to that airway for the duration of the call.
So when your colleagues are stripping the clothes off him, is your attention on the clothes or more on the airway in your job?
No, I'm maintaining the airway. If an endotracheal tube is dislodged for whatever reason, it is typically more difficult to get one in. So the integrity of that tube staying where it is and not being dislodged, that is another key aspect of airway management.
As you're doing that, do you notice what any of your colleagues are doing to help?
Like I said, they were working on clothing removal. I believe they were also getting intravenous and intraosseous access on this individual to begin medication administration. But again, I was quite focused on that airway, just making sure that it was maintained and we didn't lose any tube. We didn't lose any end-tidal CO2, which is just another monitoring device that we use to confirm that tube is in place.
How quickly do you get to leave the scene and start moving towards the hospital?
I honestly couldn't give you an accurate estimate. It didn't seem to be out of the ordinary realm, though. We were able to move within the flow.
In addition to Mr. Keefe being very cold, did you notice any other injuries on him?
So I noted that he had a hematoma right above his right eye.
Could you explain to us what that is?
Yep, it's just, for lack of a better term, it's just a big egg. He had a pretty good bump over his eye.
And you said his right eye.
Yes, sir.
Did you know how that hematoma was caused?
No, sir.
No idea?
No.
In addition to the hematoma above his right eye, what other injuries did you see?
There were also several scratches on his right arm, just below his shoulder and traveling down his right humerus. They terminated right about his right elbow, just above it.
Those scratches, have you also described them as abrasions?
Yes, sir.
Is there any difference in your mind, difference between scratches and abrasions?
Nope. These were they were deep and they were not bleeding, but they were notably deep.
Did you ever describe it as furrows?
I did.
And in describing those scratches, do you have any idea how they were caused?
No, sir.
Okay. And did you notice any other injuries on Mr. O'Keefe?
No, sir. Those were the only ones that we noted. As I mentioned, we suctioned a little bit of blood out of the back of his airway as well. I believe it was blood, mucus, and saliva. But those were the extent of the injuries that I was able to note.
Did you notice anything about the back of his head?
Actually, yes, I did. I apologize. There seemed to be a little bit of matted blood around in his hair around there. Really didn't see anything too obvious at the time. He was also placed in a cervical collar as well. following intubation, and that was kind of there just to maintain his cervical spine. But there was, like I said, there was noted to be a little bit of dried blood on the back of his head.
At some point, did you finally make your way with Mr. O'Keefe to the Good Samaritan Hospital?
Yes, sir.
And just share with us what happens when you get there.
So after we got there, we handed off care to Good Samaritan Medical's physicians and ER nurses. We were able to give a report to the physician of just basic what we've done, what we've given for medications, in my case, what he was intubated with, and how he was being ventilated, how well he was being ventilated, and any other further pertinent information. Typically, we noted that Tony was the lead paramedic, so that is typically his. He kind of holds the room for a minute when we get in there and gives a big rundown, and then we back off and let Good Samaritan take over.
When the defendant told you that she hit him, did that have any significance to you?
No, sir.
Did it reconcile with the injuries that you saw before you that Mr. O'Keefe was suffering from?
No, sir.
And so at that point, was that information insignificant in perspective of your care?
Sustained.
Okay. What role did that information play in your care after the defendant told you she hit him? How did that contribute or not contribute to what you were doing?
It really didn't help at the time. Again, I wasn't able to chase anything down from that. I just kind of took it, noted it, and moved on with my aspect of the cardiac arrest.
Okay. Have you had an opportunity at any point to see any video of that morning taken from any source, a police car, dash cam?
Yes, sir.
Okay. Your Honor, I'd like to introduce a video stream.
So this will be in evidence? There are agreements with some of the evidence already?
I believe there's no objection, but I don't want to speak for the defense.
Okay, thank you. Yes, you can show it.
And for the record, if I may note, this is Cruiser 683 Stream 2. I'm sorry. It is Cruiser 683 Stream 2. I'm going to ask to play a portion of it that's relevant to Mr. Nuttall. Ms. Gillum, if you would please move to 6:11 a.m. Please stop the video. Mr. Nuttall, do you see the red lights reflecting on the left?
Yes, sir.
Do you know what those red lights are?
Presumably, those would be ambulance 1.
Yeah, so not what you presume. Do you know what they are, sir?
And those are the lights for ambulance 1.
Do you see the weather conditions as it's depicted on this video?
Yes, sir.
Oh, as you stood outside, was it same or different to how it appears on this video?
That is the same.
When you look to the left, you see a straight line about an inch or two from the left of the screen. Do you know what that item is?
Sorry, sir. Repeat the question.
If you look to the left of the screen,
Yep.
you'll see a straight item from the bottom halfway up the picture. Do you know what that item is on the
Believe
video?
that's a flagpole, sir.
Do you see a little bit of movement of bodies near that flagpole?
At the present time, no.
Okay. Could we continue to play, please?
Yep, there they are.
Could you stop, please? Did you see the first person in line now behind the person in front of the person with the blue hat?
I'm sorry, sir. Could you back it up like 10 seconds?
Certainly. Keep going, please. Do you know who that person is?
I believe that's me, sir.
Okay. Could you please continue? Is this your first assessment?
Yes, sir. This is ascertaining any signs of life or breathing.
Is that you approaching?
Yes, sir.
Could you stop, please? After informing you return, is that after firefighter Flamati called you?
So right after that, when I turned around, that was when Tony said, "Hey, we're working this."
Okay. Please continue. Stop, please. And do you see a person come over to where you are?
Yes, sir.
Is it at that point or another moment when the defendant said, I hit him, I hit him, I hit him?
It was right there, sir.
Could you continue, please? Could you stop for a moment? There's no voices or noises from people coming through that audio. When you were there that night, throughout the event, was it silent or were people speaking? Did you hear people speaking?
There was, as I noted when I got out of the truck, there was quite a bit of screaming. It was quite chaotic. The wind was also a factor, but there were people around. They were speaking within themselves too, but there was screaming, there was wind, and there was different side conversations as well.
And when you were working on Mr. O'Keefe, were you having conversations with your colleagues?
Yes, sir.
They're not picked up on the audio?
No, sir.
Please continue. Sir, are you still at the flagpole?
Yes, sir. I'm kneeling at the head of the patient.
Are you included in that group of first responders?
I am not, sir. I have actually exited to the side with the bags. I believe I'm entering the ambulance at this point.
Okay. Thank you. We can conclude the viewing. With the court's permission, I'd like to approach and show a few exhibits to Mr. Nuttall. They've been shown to the defense.
Yes,
Thank you. May I approach?
yes.
Thank you.
No objection. I'm going to show you a photograph.
Yes, sir.
Sir, do you recognize what's in that photograph?
Yes, sir. Those are the scratches on Mr. O'Keefe's arm.
Does that appear the same as when you saw his arm that morning, or is there any differences? And if there's any differences, can you share them with us?
That appears how they were to me at the time of the incident.
Okay. May I approach again, Your Honor?
Yes.
I'd like to introduce this as an exhibit, please.
Okay.
Here also.
I'm going to hand you a...
Hold on.
I'm sorry.
Thank you.
Pardon me, Your Honor. May we publish to the jury?
Yes.
Is that the photograph you just identified on the screen?
Yes, sir.
Showing you a second photograph, I'd like to ask you some questions about it.
Can we take that one down, Mr. Brennan?
Yes, of course.
Please, Ms. Gilman.
Thank you. Does that photograph, do you recognize that area?
Yes, sir.
Is that the same or substantially the same area where you helped try to treat John O'Keefe?
Yes, sir.
Does that look to be a fair and accurate representation of the area?
It does.
With the court's permission, I would introduce this as an exhibit, please.
Okay, and there's no objection to any of these three?
None.
Okay, yes.
Thank you.
Thank you.
With the court's permission, could I publish exhibit 2?
Yes.
And sir, that's what you recognize as the area where you were helping to treat John O'Keefe.
Yes, sir.
I've left one last photograph in front of you.
Yes, sir.
And do you recognize that?
I do.
Tell us about any differences between when you were there and what you see in that photograph.
The street appears to be plowed. There's bare pavement. The weather conditions are significantly better. It is also daytime.
If we could take down that exhibit 2, Ms. Gilman. May I approach, Your Honor?
Yes,
I would move to introduce this as exhibit 3.
all right.
With the court's permission, I'd like to publish exhibit 3.
Sure.
Is that the photo you just identified?
Yes, sir.
Okay, we can take that down, thank you. Thank you, sir. I have no further questions, Your Honor.
All right. Jackson?
Good morning, good afternoon, Firefighter Nuttall.
Good afternoon, sir.
Nice to see you again.
You as well.
Before your testimony this morning, how many conversations had you had with any member of the prosecution team in anticipation of your testimony today?
I believe it was 3, sir.
When were those?
I could not give you dates off the top of my head.
Give me a time frame. Within the last 3 weeks, within the last 3 months, last 3 days?
Within the last 3 weeks, I believe one the week after that, and then one last night.
One
Last night.
last night. What you did discuss, let's take them in order. First of all, who'd you meet with 3 weeks ago?
I met with Mr. Brennan and his staff.
And when you say his staff, who else?
I honestly couldn't tell you, sir.
Mr. Lally?
No, sir.
Male, female?
One female, one I believe, state trooper.
Okay. Had you ever met State Trooper Tully previously?
Yes, sir. Actually, I believe that was him.
It was State Trooper Tully?
Yes, sir.
Whom you've met with several times, correct?
Prior to that, I believe only once or twice.
He was the one that he has formally interviewed you previously, correct?
I believe he arranged the meetings with Mr. Brennan, but
Okay.
Beyond that, I can't speak to.
What did y'all discuss 3 weeks ago?
The first meeting, going in order, it was mostly just kind of an introduction. I had not met Mr. Brennan yet. I really didn't know him. So it was mostly that, and then just kind of seeing where we were at with testimony, going over previous testimony and in that sort of realm.
Prior to today, how many times have you testified under oath concerning the incident on January 29th, 2022?
Once at a grand jury hearing and once last year.
All right. As a matter of fact, last year in this courtroom.
Yes, sir.
Okay. Did you look over your testimony at the grand jury 3 weeks ago during that meeting?
No, sir.
What about the testimony from last year?
We did go over the testimony from last year. Yes, sir.
Were there any issues that Mr. Brennan or anybody else in that meeting brought up concerning any of your testimony?
There was just a question of how many times the I hit him came up. It was 3 times.
And were you advised that that's not what you said at your testimony last year? Said it
No,
was
sir.
2 times?
What was that?
You said it was 2 times last year?
I honestly can't recall, sir.
Okay. But you just saw that, or you just read that and went over that 3 weeks ago.
I believe so, sir. Yeah.
But you can't remember, as you sit here today, just 3 weeks ago, what y'all discussed in terms of how many times you previously testified that you heard the phrase, I hit him.
So previously testified possibly to 2, but it was 3.
Okay. Your memory is clearer now than it was, for instance, a year ago when you testified.
Repeat that?
Sure. Your memory is clearer now, as you sit here, that it was 3 times you heard that, than it was a year ago when you testified that it was 2 times.
Yes, sir.
Okay. Does your memory get better with time generally? Your memory. I'm not talking about the royal you. I'm talking about you.
In certain settings, I mean, there are certain things about different aspects that I recall better than others.
Okay. And does your memory tend to get better, or does it fade over time? That's my question.
It can fade over time, but it depends on the context.
But in this case, you're telling this jury that your memory is better now than it was a year ago when you testified about the exact same circumstance, correct?
Yes, sir.
Okay. You then met about a week after that, which would be 2 weeks ago.
Yes, sir.
Who'd you meet with then?
The same group.
And what did you discuss at that meeting?
Again, just prior testimony, and that was really the gist of it.
And tell me the specifics of the prior testimony that you...
Again, it was the how many times we had talked about saying I hit him. Again, it was 3 times. And then there was also the video that was just played for me.
If, I'll take the video in just a second. If y'all had met 3 weeks ago and you indicated to Mr. Brennan that it was actually 3 times, not 2 times that you heard the I hit him, why did you need to discuss it again a week later to verify the 3 times versus 2 times?
Not sure, sir. That was just the way that the conversation went. And I just, again, repeated what I said and what I remember from that morning.
Well, tell me about that conversation. Did Mr. Brennan say anything like, well, are you really sure that she said it 3 times?
It was that morning what was said to you. And I said, I hit him. That was how it went that morning, and that was how I remember it.
Okay. And did Mr. Brennan say, well, that's not consistent with how you've testified previously concerning the number of times you heard the I hit him phrase?
Yes, sir.
He did say that.
He wanted to, he acknowledged that I had said it twice. However, again, as I mentioned, it was said 3 times to me.
So now you do remember last year that you only said you only said that it was repeated twice.
One more
Correct?
time, sir.
So now you do recall that last year when you testified, it was inconsistent with how you're testifying today. Let me put it that way. Correct?
I believe I said I hit him twice on the stand last year.
Right. And if you're saying I hit him 3 times instead of twice, that, Firefighter Nuttall, is inconsistent with your testimony today, correct? You
Yes,
agree
sir,
with that?
but that is how it went that morning, though, sir.
Okay, that's not my question. Let me see if I can do it again. So I'm asking you, if you testified last year
Yes, sir.
that you heard the phrase twice, and now a year goes by and you're testifying in front of this jury this year that you heard it 3 times, those 2 statements are inconsistent with one another, correct?
Yes, sir.
Okay. Did you talk at the meeting 2 weeks ago about any other inconsistencies with your testimony?
Not to my knowledge, sir.
Well, you were there. You
No.
say not to my knowledge, meaning,
No, sir, we did not.
okay. So it was just about the number of times that you heard the phrase, I hit him, correct?
Yes, sir.
All right. You cleared that up in the 2 meetings, 3 weeks ago and 2 weeks ago. What did you talk about last night?
Mostly just making sure that everything was as it had been. I mean, and by that, I mean, it was 3 times, and that we were continuously making sure that everything was the way that it had happened that morning.
Everything was the way that Mr. Brennan wanted it to be.
No, sir. The way that it was I remember it, and I recall it happening.
Okay, so he asked you 3 weeks ago about how many times you heard that phrase.
Yes, sir.
You changed your testimony at that time and said it was 3 times instead of 2 times. We agree on that, correct?
Yes, sir.
Then he called you a week later, or met with you a week later, and again reiterated, making sure you stick with that testimony that it's 3 times, not 2 times, correct?
Yes, sir.
And then last night he called you just to make sure one more time you're going to stick with that testimony that it was 3 times, not 2 times, correct?
Yes, sir.
Hold on just a second. May I have just a moment, Your Honor?
Yes.
Okay. And when you talked last night, did you assure Mr. Brennan, nope, 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 when we come in tomorrow, I'm certainly going to say it was 3 times, not 2 times?
No, sir. I told him I would tell my recollection of that morning.
Okay. And did you tell him that what my recollection is, I'm going to tell the jurors it was 3 times that I heard it?
That was what I heard.
Okay. Did you tell him that's what you were going to say today?
No, sir.
You didn't?
I told him I was going to tell him what I remembered from that morning.
Which was what?
I hit him, I hit him, I hit him.
Which is how many times?
3 times, sir.
And that's inconsistent with what?
I believe a year ago.
Okay. Now, you also talked about, I want to get back to the other thing that you talked about. You said that at some point, either in the meeting 3 weeks ago, the meeting 2 weeks ago, or the meeting last night, you were shown a video.
Yes, sir.
Which one of those meetings were you shown a video?
I believe the second one.
Okay. Were you shown the entire video?
No, sir.
Just the clip that we saw?
Yes, sir.
Okay. What did y'all talk about in relation to that video?
Mostly nailing down who was who in that video.
Okay.
Being the other personnel on scene, where I was, and that was about it.
He showed you the clip that you showed, he showed you the clip that you just seen on direct examination, correct?
Yes, sir.
Did you tell him where you were?
Yes, sir.
Did Mr. Brennan ask you to define exactly where it was that you supposedly heard this phrase, I hit him?
No, I was able to give that to him, sir.
Okay. And what you told him was that moment when you see my client walk over sort of to the left of the screen, correct?
Yes, sir.
And you defined, that's the point at which she said, I hit him, I hit him, I hit him.
Yes, sir.
And that's in response to your question. I want to make sure I'm clear about this. You asked, do you know him?
Yes, sir.
And she repeated the phrase 3 times, I hit him, I hit him, I hit him.
Correct.
Okay. We'll talk more about that in just a second. Did Mr. Brennan ask anything else about that specific video?
No, like I said, he kind of asked me to point out different individuals on the scene, and that was really the extent of it.
You saw that same video last year when you testified, correct?
No, sir.
You didn't see it last year?
Not to my knowledge, no.
In preparation for your testimony last year?
I did not.
Did you see it before your grand jury testimony?
No, sir.
Okay, so this is the first time that you've seen it.
Yes, sir.
And you were able to establish for Mr. Brennan exactly when it was that you believe you heard the statement based on your view about 2 weeks ago of that video.
No, that was the way that I remember it.
Right,
That
not
morning.
a trick question. My question is much more simple. You were able to establish after 3.5 years now exactly where you were and where Miss Reed was and who else was around at the time that you believe you heard those 3 statements in order. I hit him, I hit him, I hit him.
Yes, sir.
Okay. You testified last year as well that there is a normal protocol for removing clothing from a patient, and it's essential to just discard it and get it away from the patient so that you can concentrate on the life-saving measures that you're undertaking, correct?
Yes, sir.
That could be done in the ambulance, it could be done in the hospital, it could be done in situ, out there in the field, correct?
Yes, sir.
But the point is you want to get as much clothing off of the person as possible so that you can assess that person's physiology.
Yes, sir.
There's not really a lot of care taken to preserve the clothing from an evidentiary standpoint, in your view, correct?
And we're trained to try and, just to take example of a shooting, try not to cut through the entrance wound of the clothing.
Fair enough, fair enough. I mean, when you're literally trying to save someone's life, your job is to get the clothing off and get it out of the way.
Yes, sir.
You're not sticking it in an evidence bag and sealing the evidence bag, things of that nature.
No, sir.
So it might end up on the ground.
Yes.
Right? Might end up with some debris on it.
Yep.
Might end up on the floor of the ambulance.
Yes, sir.
Could end up in the floor of the hospital, or on the floor of the hospital. Is that right?
Yes, sir.
Okay. And if it's tossed in the floor of the ambulance, the clothing may well pick up debris from the ambulance.
Oh, yeah. Yes, sir.
Or the debris from the floor of the hospital or wherever. Is that yes?
Yes, sir.
Okay. You testified previously at the grand jury in April of 2022, correct?
Yes, sir. I believe so, sir.
Okay. So this happened in January of 2022, that same year in the springtime. You testified at the grand jury, April 20th, I think it was.
Yes, sir.
Does that sound right?
Yes.
Okay, I want to take you back to that testimony for a second. You testified at that hearing that Mr. O'Keefe was, quote, dressed appropriately for the weather. You remember that?
Yes, sir.
All right. It was obviously well below freezing at that time.
Yes,
That night that you responded.
it was.
We just seen the video. It looks cold as hell, right?
It was chilly.
All right. The wind was howling.
Yep.
It was snowing. Is that right?
Yes, sir.
And you testified that John O'Keefe, quote, had a heavy coat on and possibly 2 other layers of clothing.
Yes, sir.
In April 2024, you reiterated your very specific memory of and you even called it a puffy heavy coat that he was wearing, which was then removed so that you could assess his injuries, correct?
Yes, sir.
All right. Not to get too colloquial, but a puffy coat is like, it's got down and stuff in it, right?
Correct.
Looks kind of like Stay Puft Marshmallow Man, right?
Yes, sir.
Okay. Pretty distinctive article of clothing.
Yep.
And you testified last year that Mr. O'Keefe was wearing that clothing, which you had to remove or somebody had to remove in order for him to be properly assessed.
I did testify that way. Yes, sir.
Okay. And you mentioned that your memory of that big, heavy winter coat was as clear as your memory of other specifics in this case, correct?
Yes, sir.
I asked you that exact question, didn't I?
You did.
And I said, your memory of him having that big, puffy coat on, which stood out in your mind, was just as clear as the other specifics that you've testified to about the case,
Yes, sir.
about that night. And turns out you were completely wrong about his clothing, correct?
Correct.
Matter of fact, he wasn't wearing a coat at all.
No, sir.
He wasn't wearing a winter coat, correct?
Nope.
He wasn't wearing a heavy winter coat, correct?
Correct.
And he wasn't wearing a puffy, heavy winter coat.
He was not.
Yet you testified that he was wearing all of that, and that was clear in your mind at the time.
Yes, sir.
Did Mr. Brennan bring that up during the meeting 3 weeks ago?
He asked about what I had meant when I said appropriately dressed.
So you did talk about something other than just the I hit him, correct?
Yes, sir.
When I asked what y'all talked about, why didn't you tell us that?
To be perfectly honest, sir, I did not remember until right now.
So your memory is fading even after 3 weeks.
Yes, sir.
Got it. The fact is, well, let me ask you a different question. Did Mr. Brennan tell you what Mr. O'Keefe was actually wearing
No, sir. Actually, I believe you did.
last year, didn't I?
Yes, you did.
It's a short sleeve t-shirt and a little thin wool hoodie, right?
Yes, sir.
Wasn't wearing a hat.
No, sir.
Wasn't wearing, as a matter of fact, didn't even have a shoe on, correct?
Not to my knowledge.
And obviously, goes without saying, but I'm going to ask it anyway, that's not being appropriately dressed for the winter.
No, sir.
Yeah. You indicated that you did notice certain injuries on Mr. O'Keefe's person.
Sir.
Once you got him back in the ambulance, obviously it's lighter, meaning brighter lights. You have more equipment in the back of the ambulance. You can better assess somebody's well-being, correct?
Yes, sir.
And you indicated you had a, quote, much better picture of what we were dealing with, correct?
Yes.
You noticed once in the back of the ambulance that he had trauma to the right side of his head.
Correct.
And as a matter of fact, when you were pointing at it, I'm doing that on purpose because you pointed to the right side of your sort of forehead above your right eyebrow, correct?
Yes, sir.
Okay. The majority or the worst injury that Mr. O'Keefe suffered was actually to the back of his head, which you indicated, you noted, was quite matted with blood, correct?
Yes, sir.
I want to talk about the injury to the right side of his head as distinct from the back of the head injury for just a second. Before I get to that in detail, let me ask you, because I just sort of want to cover the bases. You noted the back of the head injury, correct? Is that yes?
Yes, sir.
You also noted the front right side of the head above the right eye, correct?
We did.
You noted some injury to his eyes. They looked blackened.
Yes, sir.
But primarily the right eye was blackened?
Yep.
And there was a golf ball size egg, I think you put it, over his right eye,
I did.
often called a hematoma.
Correct.
And you also noted when you got his shirt off that he had scratches along the right side of his arm. Is that right?
Sir.
You indicated on direct examination today that you believe those scratches ended where? Meaning from top to bottom? And I'm not using anatomically correct
No.
language. So from shoulder to wrist, where were the scratches that you noted?
There were several. As I noted, they were on his right humerus area.
Tell me what a humerus is.
The right arm.
Biceps.
Right about here.
Okay.
No, a little further, like between where your bicep and your tricep kind of meet. Right,
Got it.
right about in there.
Okay. And what did the scratches look like?
They were deep, infamously referred to them as furrows, but they were quite deep. You could tell that there had been some material removed.
Okay. Material meaning skin and flesh.
Yes, sir.
Okay. Some biological material. Mm-hmm. Is that yes?
Yes, sir.
And were they parallel? Meaning they were going in the same direction?
Yes.
Were there any scratches below the elbow as
There
well?
were. Yes, there
Okay.
were. They were not as significant as the ones on the upper arm, but they were noted.
Okay. And those were parallel as well?
Yes, sir.
And they looked like scratches to you. That's how you described them?
They did.
Last year, when you described those scratches, you curled your fingers up, exposing sort of the nails, and drew it across your biceps. Is that what you were using to describe what the sort of scratches looked like?
I just kind of used that as a landmark, to be honest with you,
Okay.
sir. It was just kind of how I quantified it in my mind.
Okay, but what you did was you did this motion.
Yes, sir.
As you said, there were furrows, and remember there was an embarrassing moment for me.
Both of us, sir.
I couldn't understand the word furrow because of the accent, right?
Yes, sir.
All right. Let's talk a little bit about the hematoma above the right eye for a second. That's basically damage to subdural blood vessels that causes acute swelling, right?
Correct.
And a very common cause of a hematoma over one's eye could be being hit or punched in the face. We talked about that.
There could be several causes for hematoma, such as that.
Obviously. I mean, it could be a golf club, a baseball bat, or it could be a fist.
It could be.
Okay. We talked about that last year. I asked you if the injuries that you saw on Mr. O'Keefe's face, including the laceration over his right eye, was consistent or inconsistent with a physical altercation, and you said it was consistent with a physical altercation as well.
Objection to the
Excuse me?
objection to referring to past testimony before a question is asked.
So sustained.
Sure. Do you remember a laceration, in addition to the hematoma, about a 0.8 centimeter laceration over his right eye?
I do.
Tell me I'm using a word that maybe not everybody understands. I didn't understand it when we first started this thing. What's a laceration? What's the difference between that and a cut?
A laceration is they're basically the same thing. A laceration is just a deep cut.
Okay, so it's a parting of the skin.
Correct.
In other words, where the skin separates.
Yes.
And that can be from blunt force trauma, meaning something hits it rather than cuts it.
You can get
Objection.
Sustained.
What are some of the causes of lacerations?
a laceration, as you noted, blunt force, but you can also get a laceration from a slashing movement, from a stabbing. I mean, that is still a laceration.
What about a hematoma?
That is primarily caused by blunt force trauma.
Right. And the hematoma and the laceration were right next to each other, correct?
Yes, sir.
Okay. And you indicated last year, or let me ask you this way. Is that consistent or inconsistent with a physical altercation?
Objection.
Can you answer that?
I could not say, Your Honor.
Okay, next question.
Well, last year, you indicate you can't answer that. Last year, you did answer it, didn't you?
Objection.
So I need to see counsel at sidebar for just a minute, please.
Mr. O'Keefe. Do you
Yes,
recall who is being punched in the face? Can that lead to a small laceration like you saw and a hematoma like you saw?
Objection.
I'm going to allow it. Can you answer that question?
I couldn't speak to how that injury occurred.
Is it consistent? Are those injuries, just those injuries, are those consistent with being punched in the face?
Those injuries could be sustained from a numerous ways.
And I
Yes,
didn't-
it could be from that. It
That-
could be from others as well.
Okay, so that's what I'm asking you. It could be. In other words, it's consistent
Yes,
with
sir.
being punched in the face, correct?
Correct.
Thank you. I want to ask you about this statement that you indicate that you heard that now is 3 statements, 3 phrases, correct?
Yes, sir.
When you heard this statement, describe for me exactly where you were. What were you doing and who was around you?
I was knelt at the head of John O'Keefe with a bag valve mask, delivering ventilations. Firefighter Kelly was to the right, and Firefighter Flamati was on the left side of Mr. O'Keefe, and the 3 of us together were working to perform CPR and ventilations.
And your job, and I hate to butcher it, but
Nope.
you'll correct me.
Yes, sir.
Your job was to do the airway, correct?
Yes, sir.
And I'm picturing a big balloon-like apparatus that you put over the patient's mouth and
Exactly.
squeeze it.
Yes.
That's as opposed to, it's an advancement on just mouth-to-mouth resuscitation, correct?
Correct. Yeah.
You were the airway person doing the squeezing of the bag.
Correct.
What was Tony Flamati, firefighter Flamati, doing?
He was starting CPR, in which that point was taken over by Firefighter Kelly.
Okay, so firefighter Flamati, when you say starting CPR, describe what that means. What is the physical act of CPR?
So you put both hands together like this, one on top of the other. You put it right on top of the sternum, and you begin doing chest compressions 2 inches deep, allowing full recoil for 100 to 120 beats per minute, compressions a minute to sustain a cardiac rhythm. You're manually making the heart beat with each compression.
Which means that is a rhythmic pumping motion, correct?
Yes, sir.
So if you see someone doing CPR, you're probably going to see their shoulders moving up and down and moving rhythmically, correct?
Correct.
Do you remember what firefighter Flamati was wearing? You had just come off of actually you were just coming onto a shift, so you didn't have all your foul weather gear officially, correct?
I had my puffy jacket. I
Okay.
had my Canton Fire jacket.
Got it. Firefighter Flamati, on the other hand, had a bright yellow jacket,
Correct.
sort of reflective and a safety jacket.
Yes, sir.
And he was kneeling to your left at the time doing, have I got that right?
Yep, nope, yep, you got that right.
Okay, he's kneeling to your left at the time doing chest compressions. That's when you indicate that Miss Reed walked over and made the statement.
Correct.
And Kelly was there as well?
Yes, sir.
Kneeling right beside all 3 of you as firefighter Flamati was giving the chest compressions, correct?
Yes, sir.
Okay. You indicated that the statement was in response to a question that you asked of my client, do you know him?
Yes, sir.
Is that right?
Correct.
And she responded to you with the phrase that you've used, I hit him.
I hit him, I hit him, I hit him.
Right. So it's absolutely clear in your mind when that statement was made. You were knelt down over Mr. O'Keefe. Firefighter Flamati was doing the CPR, and Kelly was with the both of you when you posed that question.
Yes, sir.
It's a very detailed memory.
Yes, sir.
You indicated, Mr. Brennan, that sticks out in your mind. Is that right?
It does.
But that's not at all what you told Trooper Proctor on February 8th, just 10 days after this incident, is it?
I don't recall what I told Trooper Proctor.
I thought your memory got better with time.
I don't recall that meeting.
Okay.
I recall meeting with him, but I don't recall the extent of what was discussed.
You literally don't recall anything that was discussed in that meeting in that formal interview with the lead detective on this case.
We discussed the case, but I don't, in his words, I'm not sure what he put down.
What you said to Trooper Proctor on February 8th, 10 days after this, was you overheard Miss Reed say, "I hit him" one time to another female that she was talking to. Correct?
Objection.
No, I'll allow it. Did you say that?
I have no memory of this, Your Honor.
Okay, next question.
Did you say that her statement was an answer to a question posed by the female or a discussion with the female?
Break that down for me, sir.
Sure. Did you tell Trooper Proctor on February 8th that what you heard was Karen Reed speaking to a female, not answering a question that you posed?
Again, I don't recall that specific question.
Did you tell Trooper Proctor on February 8th while you were rendering aid, and at the time you heard the statement, Miss Reed was actually praying over John? Your words, praying over John.
I don't recall ever saying that.
May I have just a moment, Your Honor?
Yes.
Did you say that you observed Karen Reed to have blood on her face from providing mouth-to-mouth breaths to Mr. O'Keefe prior to your arrival?
I remember Miss Reed having blood on her face, presumably from attempting CPR.
Do you remember telling Trooper Proctor on February 8th that you saw her with blood on her face from CPR?
I do.
So you remember that portion of your conversation with Trooper Proctor, correct?
Yes, sir.
But the praying over John, praying over the victim, you don't remember.
I don't remember ever saying that,
And
ever.
And the statement, "I hit him" to another female, you also don't remember that.
No, sir.
Would it refresh your recollection if you were to look at a report
Yes, sir.
authored by Trooper Proctor? May I?
Yes.
May I direct the witness's attention to the second page, Your Honor?
All right, why don't you take a look at that, sir?
May I approach, Your Honor?
Yes.
Sir, did you have an opportunity to glance at the report that you were just shown?
Yes, sir.
Does that refresh your recollection about your conversation with Trooper Proctor that he put in a report?
It does not, sir.
So as you sit here, you have no memory of what you just read in this report from Trooper Proctor, the lead investigator on the case?
I have no recollection of ever saying that anybody prayed over anybody ever in this case.
You did see it in his report, though.
Sustained.
You've admitted under oath that your memory of the events at that time, from that time frame, January, February 2022, is faulty, correct?
No, sir.
In your April 2024, it's April 30th, 2024 testimony from last year, you were asked whether or not your memory was a little faulty And your answer was absolutely, correct?
Could I have a page and number,
Where
please?
is that, Mr. Jackson?
Volume 8, page 151, lines 14 through 16.
Can you read the lines again?
Lines 14 through 16. I'll just allow counsel to get that up.
If we could pose the entire question and give content to it, please.
Okay.
May I?
Yeah, so do you intend to show the whole question?
The whole question that I asked and his answer, yes.
All right, and I'll give you the opportunity on redirect, Mr. Brennan, if it's not. Go ahead.
Is it true that in answer to the question, quote, so it's fair to say your memory is a little bit faulty as it pertains to that time frame, your answer was absolutely. Correct?
From last year?
What you testified to last year about conversations that you had with Trooper Proctor around February 8th of 2022.
Yes, sir.
And you would agree, as you sit here, that your memory is still faulty about your conversation with him,
With
correct?
Trooper Proctor? Yes,
Yeah.
sir.
So you're not saying you didn't say that the statement was made to a woman, correct?
Objection.
Are you saying that?
No, ma'am.
Okay, next question.
Thank you. And you're also not saying that you didn't say to Trooper Proctor that you saw Karen Reed praying over John O'Keefe.
Objection.
So I'd like you to ask that differently. Did you say that?
I have no recollection of saying that ever.
Okay. Next question.
My point is, if you have no recollection of it, you're not denying saying it.
Objection.
Are you denying saying it?
Yes.
Okay.
So you do have a recollection that you never said it. Do you understand the difference?
Oh, sir, I don't believe I've ever said praying. That's really not something that I would have said. I didn't see it that day. It didn't happen. I don't remember ever saying prayed
You didn't
in
see
regards
it
to this case ever.
You didn't see it that day, and it never happened. That was your words just now, correct?
Break that down for me.
You didn't see it that day, and it never happened. That's what you're saying about the praying statement, correct?
Yes, sir.
And in that same exact statement, you also included the phrase, I hit him, correct?
No, sir.
In the statement that you made to Trooper Proctor,
The report that Trooper Proctor wrote?
correct?
Again, I don't remember ever saying the words praying over him. I do distinctly remember I hit him, I hit him, I hit him.
Which doesn't appear in that report, does it?
Objection.
I'm going to sustain that, Mr. Jackson. You directed him only to page 2.
Understood, Your Honor. I'd like to show you a short portion of a video, the same video that you were asked to look at on direct examination. And Your Honor, I pray to the court, I can certainly mark it as a defense exhibit or for
So is this
identification.
going to be an exhibit by agreement?
It is.
It
Okay,
is.
So we now that, Madam Court Reporter, thank you.
Exhibit 4, so marked.
Thank you, Your Honor. With the court's permission, may I play a portion of that video for the jurors, publish it?
Okay. Which portion, so people know?
I'm going to start it at about, I want to say 6:55. Mr. Wall could cue that up. Before you play it, can we have it on that screen as well, or is it only playing to this screen?
I don't know. When Ms. Gilman did it, it was both. Great.
There we go. All right. Before we play it, can I ask you a quick question about this?
Sure.
It appears that this is paused. Do you recognize this as being the same video that you were shown this morning by Mr. Brennan?
I do.
All right. Describe the scene.
So that is 34 Fairview Road. The lights in the background, I believe it is either right as we pulled up or right as we're pulling up.
Okay. Same dash cam video.
Sir.
Can we scroll this to the 6:55 runtime spot, please? Pause it. Okay. Do you see the individual on the left? Far, far, far left.
Yeah, the jacket?
Correct.
Yes, sir.
Who's that?
I believe that's firefighter Flamati.
You previously indicated that when you heard Ms. Reed make this statement, that firefighter Flamati was on his knees providing CPR at the same time you were knelt down providing the airway.
This isn't when it was
That's
stated.
not my question. Is that what you said?
Can you repeat the question, please?
Sure. You indicated earlier when you heard this statement by my client, you were very detailed. Firefighter Flamati was knelt down providing chest compressions at the same time you were knelt down providing airway support for Mr. O'Keefe, correct?
I had also said that at some point,
That's a
firefighter
yes or no
Flamati
question.
Objection.
So I'm going to let the witness answer the question.
had transferred CPR to firefighter Kelly. Firefighter Kelly did take over compressions at one point.
Okay. That's not my question.
Okay.
My question is an easy one. Did you say that when Miss Reed walked over to you and you had this dialogue with her, she made that statement, that firefighter Flamati was on his knees providing chest compressions at the same time you were knelt down providing airway support?
Yes, sir.
Okay. Firefighter Flamati, your testimony, appears to be standing up right there, correct?
Yes, sir.
Let's play the video forward for just a second. Stop it. What did you see firefighter Flamati do just now?
I believe he just knelt down.
Okay. So at this point, he's kneeling for the first time, correct?
Yes, sir.
And he's about to provide chest compressions as your memory serves, correct?
Yes, sir.
All right. Let's go ahead and play it forward. Pause. Did you see my client in that photo? In that clip?
No, sir.
You didn't see her?
Oh, no, I did see her, yeah.
Yeah.
I don't see her on right now.
Right. She just walked off frame, correct?
Yes, sir.
Let's go ahead and play it forward. Stop it. You see my client walk back into the frame?
Yes, sir.
At this point, you were watching firefighter Flamati. He appears to be now providing CPR, correct?
Yes, yes, sir.
Okay. And my client is nowhere near you, correct? At least for this clip.
No, sir.
Okay.
Correct.
And the clip that I just played before, the few seconds that I played before, nowhere near you, correct?
Correct.
Is that right?
Yes, sir.
Let's go ahead and play it forward. Pause it, please. What do you see happening on the screen from screen right to screen left at this juncture?
We're bringing in the stretcher.
Okay, go ahead and play it. Pause it. Do you see where my client is right now?
Can you back it up 2 seconds? I'm sorry, I lost
With
view.
the court's permission, I need to ask the
Yes.
court's permission. Thank you. Okay, let's go ahead and play it. Pause. Did you see my client?
Yes, sir.
Where is she in the frame?
Behind that other individual.
Behind the SUV?
I believe she's in front of the SUV and behind the other individual.
Okay. I meant the SUV, that's the white SUV that's in
Yes, sir.
the far distance.
Yes.
That's the back of the SUV. She's behind it, right?
Correct, yes.
Okay. Not near you.
No.
Okay. Let's go ahead and play it. Go ahead and pause it. Do you see what firefighter Flamati is still doing throughout this entire clip?
Chest compressions?
Okay, let's go ahead and play it. Pause. What's happening now?
Where Mr. O'Keefe is on the scoop stretcher and he's being transferred to the ambulance stretcher.
So that's the entire time Mr. Flamati, firefighter Flamati, was giving chest compressions. It's captured right here on this video, correct?
Yes, sir.
Okay. And now Mr. O'Keefe is up on the stretcher, and you are no longer knelt down,
No, sir.
and firefighter Flamati is no longer knelt down,
No, sir.
and you're now following the stretcher with, it looks like, 2 or 3 other EMTs, correct?
I am not in that frame, sir.
Okay, so you've walked away.
Yes, sir.
All right. Let's go ahead and play it forward. Pause it. You see where my client is?
Yes, sir.
Go ahead and play it. Do you see firefighter Flamati or firefighter Kelly continuing to give chest compressions?
Yes, sir.
Which one is that? Do you know?
Believe it's firefighter Flamati.
Flamati?
Believe so.
Okay, so he's still doing all the chest compressions from start to finish?
Yes, sir.
Okay. And what's happening right now?
Now we are transferring to ambulance 1.
And where's my client?
Right front and center.
May I have just a moment, Your Honor?
Yes.
If I may have just a second. With regard, just a couple of more questions with the court's permission.
Okay.
I'm going to change gears. With regard to what you talked about on direct examination, the hypothermic conditions, you're not a medical doctor, correct?
No, sir.
You don't diagnose patients?
Sir.
You're not diagnosing that John O'Keefe suffered from hypothermia that night?
No, sir.
Thank you. That's all I have.
Okay. Can you follow up, Mr. Brennan?
Please. Firefighter Nuttall, the video the defense just showed you, did you notice any differences between that video and when I showed it to you, and that it doesn't have the time on it?
Yes, those were 2 different time frames on that video.
And when we spoke about when the defendant said to you, I hit him, that wasn't shown to you in that video just now, was it?
No, it was not.
So if we go back, will you be able to explain where you came from and firefighter Flamati came from and when you first went over to John O'Keefe?
Sure.
With the court's permission, Ms. Gilman, if you could start that video. I think it is 6:11, please. Now stop it there. Do you see that this exhibit has timestamp on the top?
Yes, sir.
Okay. Please continue. Could you stop, please? Do you see the red lights on the left?
Yes, sir.
Is that when you believe that you first arrived?
Yes, sir.
And that note says 6:11:05. Could you continue, please, Ms. Gilman? Please watch to the left. Stop, please. Is that when you first arrive and walk over to help John O'Keefe?
Yes, sir. That's me.
I'll note that the timestamp is 6:11:21. Okay. Continue, please. Stop, please. Did you see firefighter Flamati come after you?
Yes, sir.
Was any of this shown to you during those questions?
No, sir.
No. Continue, please. Stop, please. Okay. Do you see the defendant in that screen?
Yes, sir.
Do you see her moving from right to left towards you?
Sustained as to the form.
Okay. What direction do you see her running in that screen from right to left?
She's running towards where the three of us are grouped.
Okay. Please continue. Stop, please. Is it at that time the defendant said to you that she hit him?
Yes, sir.
And you remember that?
I do.
Okay. I'm done with the tape. Thank you very much. Now, you were asked questions about your memory.
Yes, sir.
Okay. When you were asked the questions about Trooper Proctor, when you were saying that you didn't remember, were you referring to the conversation with Trooper Proctor, or were you suggesting you didn't remember what happened that morning?
I don't remember the interview with Trooper Proctor. I remember it happened. I don't remember the substance of what was discussed entirely. I remember we discussed that morning, but
Do you know if that conversation was recorded or just a conversation between you and the trooper?
I do not know if it was recorded.
You asked questions. I want to ask you about questions on Mr. O'Keefe, and you mentioned that there was some type of blood clotting on the back of his head.
Yes, sir.
Okay. You noticed there were abrasions on his right arm.
Yes, sir.
You noticed there was a hematoma on the right side of his head.
Yes, sir.
Did you see any bruising on his right knee?
Don't recall, sir.
Did it stand out to you that all of his injuries, all of them that you saw other than the cut on the back of the head, that they were all on his right side?
Yes, sir.
Did you notice any hematomas on his left side?
I did not.
Did you notice any scratches or abrasions on his left side?
I did not.
Did you notice any marks that would be consistent with an altercation on the left side of his body?
I did not.
You were asked about the cause, and you said that you don't know the cause. You weren't there, were you?
No, sir.
You asked if it was consistent with being punched, and you said it could be.
Yes, sir.
Could it be consistent with being clipped by a car?
Objection.
Sustained as to the form.
You were asked questions about clothing,
Yes, sir.
and you had at one point said you thought that Mr. O'Keefe was wearing a winter jacket. Do you have any memory that when you first got there, or when you first got there, do you have any memory whether there were any towels wrapped around Mr. O'Keefe's head?
I remember there was a white cloth of some sort on the scene.
Okay. And when you were asked about your memory regarding the clothing, was the clothing of what was utmost importance to you at that time?
No, sir.
And why is that?
I was, again, focused on Mr. O'Keefe's airway and ventilation.
Okay. And when you were asked about the clothing, do you remember if you added anything else about your certainty or uncertainty about clothing when you previously gave a statement or testimony?
I believe when I testified last year, I did note I had no part in removing any articles of clothing or anything like that. That was not my job in the back of the truck.
Do you remember any recognition of the fact whether you were certain or not about clothing?
Repeat the question, sir. I'm sorry.
Well, is there anything that would refresh your memory about what you had said about clothing?
Objection.
Ask a different question first.
You had mentioned that you had some difficulty about clothing. Do you remember what you had previously said.
I remember there was some difficulty of getting the individual's fingers through clothing just because they were so cold. They were difficult to manipulate. Just they really was not conducive to getting clothing off easily.
Okay. You met with me 3 times.
Yes, sir.
I had not met you before any of your prior testimonies, had I?
No, sir.
Do you remember meeting with me and discussing this case with me?
I do.
Do you remember me asking you to tell me what you remember?
I do.
Do you remember what I told you about testimony when you come into court?
Yes, sir.
What would I tell you?
I remember we discussed that just tell the truth.
Did I tell you that it doesn't matter, there is no side, doesn't matter if it helps or hurts, that you just tell the truth?
Sustained.
Did I ever suggest to you that you should stick to a story?
No, sir.
Did I ever suggest to you you should offer your testimony in any certain way?
No, sir.
When I talked to you, did I ever ask you to say anything about your testimony to this jury?
No, sir.
Other than what?
Speak to the jury.
Did I need to tell you to tell the truth?
No, sir.
And in telling the truth, did the defendant say to you, I hit him, I hit him?
I'll allow it.
Yes, sir. 3 times.
And in fact, do you remember, in addition to her saying, I hit him, I hit him, I hit him, when you asked her the question, kneeling down over John O'Keefe's body, do you remember if you ever talked about other times that she said it, not to you?
I do not.
Okay.
The answer is I do not. Next question.
Okay. Do you remember testifying previously in this case?
Yes, sir.
Okay. Do you remember at all discussing whether or not, after she left you, whether or not the defendant was still talking and speaking?
I'm sorry, sir. Repeat the question.
Do you remember, after the defendant left you and made that statement to you, do you remember talking, did you hear her speak to other people after you?
I heard her having conversations in the background, but that was not my focus at that time.
Okay. And during those conversations in the background, did you hear her talk about that same issue again?
I believe she said it several times, but the 3 times she said it to me were what stuck out to me.
Okay. And when she said it to other people, it wasn't directly to you?
No, sir.
So watch the form of the question, Mr. Bowman.
And when she said it to-
Stating the objection.
When she said it to other people, do you know who she said it to?
I do not.
I'll allow it. So the answer is I do not.
I'm sorry.
Do you remember when she said it other times who she said it to?
I'm going to see counsel at sidebar for this.
Sir, after the defendant came over to you and spoke and then left, do you remember hearing her make further statements?
Yes, sir.
And do you remember her making further statements similar
I do.
to the statement to you?
Yes, sir.
Could you share with the jury what you remember her saying, not to you, but after she left you?
I remember hearing I hit him several other times. Again, not directed to me, just kind of off in the background. I'd like to reiterate, we were really focused on the patient at that point. We were trying to provide care.
Thank you, sir.
So now, after Mr. Brennan asks you a few questions, now you remember her saying, I hit him a bunch more times. Correct?
I remember hearing it in the background several other times.
Really?
Yes, sir.
Never mentioned that on direct examination, did you?
don't remember being asked about it, sir. I remember saying what was asked to me.
You were asked, did you ever hear the defendant, Ms. Reed, say anything about I hit him? And your answer was, she said to me, in answer to my question, I hit him, I hit him, I hit him 3 times, and that's it.
To me.
You didn't clarify that, oh my gosh, she's running around like a chicken with her head cut off, screaming I hit him to everybody else under the sun.
It was, again, it was behind me in the background
right.
as I was providing patient care. Again, that was not my focus.
Okay, so you didn't really hear her say anything in the background, because you weren't focused on that, right?
I remember hearing a generalized commotion in the background, but again, that was not our focus.
So generalized commotion is very different than hearing her say, I hit him to other people, correct? You'd agree with that?
Yes, sir.
So what you actually heard was the chaos and the commotion of a chaotic scene, correct? In the background.
In the background.
As you focused on your patient care, correct?
Yes, sir.
Okay, not specific words coming out of my client's mouth, correct?
To the question that I posed, do you know him?
You're right. We're off that question.
Okay.
That question, I got it.
Yes, sir.
Triple I hitters.
Correct.
But with regard to what Mr. Brennan just asked you, the generalized commotion, to use your phrase, in the background, you didn't hear any specific words coming out of my client's mouth, did you?
I heard I hit him. But again, it was in the background and it was not my focus.
Well, why didn't you say that on direct? That's kind of an important point. That's why you're here.
Again, if it was neglected on my part, it was not intentional.
Not intentional to neglect that part for the jurors on direct examination.
No, sir.
Certainly not intentional to neglect that part of your testimony on cross-examination.
No, sir.
But you decided to bring it up on on re-cross-examination when Mr. Brennan is asking you questions again, correct?
It was asked of me. Yes,
And it
sir.
was after, of course, that your new statement that you've never testified to before, ever, is this generalized commotion included a bunch of I hit hims in the background, correct?
Sir.
And that comes after you saw the video that clearly shows that when you describe having heard this statement, my client was nowhere around you, correct?
That segment of the video that you showed me,
Yes.
that was not the time frame in which she said that to me.
Well, that was the time frame when Flamati was giving CPR, correct?
He was doing CPR down prior to that as well.
Really?
Yes, sir.
Well, you just testified that you saw him standing up in a big yellow jacket and then kneel down and start giving CPR. We just watched that video. Correct?
But again, the clip of the video that you showed me,
Right.
that was not the segment in which he said that to me.
Well, that's what you're saying now, but what I'm asking is, you described a very distinctive scene, a very, very specific scene.
Yes, sir. I remember it vividly.
She said, the I hit him phrase, when Flamati was down giving CPR, and you were kneeling down giving airway support, and he was doing rhythmic CPR chest compressions.
Yes, sir. That's what happened.
And then I showed you that very scene, didn't I?
Yes, but you showed me that clip prior to that.
I showed you the very scene that you described where Flamati gets down and starts chest compressions and never stops until the gurney is taken off the frame of the camera to the audience. Isn't that what I showed you?
That is,
I didn't catch your name. Question. Can you do it again?
Sure. I don't know if I can do it again. I showed you the scene where firefighter Flamati gets down on his knees, begins chest compressions, and never stops until that gurney is taken off camera, off frame, into the ambulance. That's the clip I showed you, correct?
that is the clip you showed me.
And that's exactly when you described your vivid memory from 3.5 years ago. That's exactly the scene that you described when my client supposedly said, I hit him to you, correct?
Again, the clip that you showed me, that was not when it was said. That segment that you showed, that was not when it was said. It was said prior to that, when the
Yeah.
three of us were together.
So Flamati was not giving chest compressions then.
He was. The CPR was a continuous effort throughout the resuscitation.
But we saw him start it. Officer, Firefighter Nuttall, we saw him start it. We saw him walk into the frame, kneel down, and begin the chest compressions, didn't we?
We did.
And at no point At that time or after, did my client even approach you, did she, in that clip?
She did.
What?
Objection.
Just a question.
Sure,
Mr. Johnson.
sure. Do you need to see that clip again?
Yes, please.
We're not going to show the video again. We've seen 2 videos. Which one is marked?
The
The
Commonwealth.
one with the timestamp in
Right.
the top?
It's the exact same video. One has timestamp, one doesn't. Just to be clear, you described a very detailed scene in which firefighter Flamati got down on the ground, on his knees, and began CPR.
Yes, sir.
We saw a clip that it played fully through.
Mm-hmm.
Starts and stops, but it played fully through, correct? You
Yes, sir.
agree with that? That was true and accurate video of what happened that day,
Yes, sir.
that morning, correct?
Correct.
And from the time firefighter Flamati began his CPR, he never stopped. Went all the way through until the burning was taken off the camera, correct?
Correct.
You also described very clearly, before you saw the video, that the time when my client walked over and you had this dialogue and you heard this statement, it was during the time that firefighter Flamati was given the CPR, correct? You described it.
Yes, sir.
But when we actually see firefighter Flamati giving the CPR, as per your description, at no time did my client walk over and have a conversation with you, did she? In that video?
She did in the video.
In the portion that Mr. Brennan played you, was firefighter Flamati giving CPR at that point?
As I said previously
Was
as well.
he or was he not? Yes or no?
Objection.
I'm going to let the witness answer the question.
Firefighters Kelly and Flamati were trading off CPR. Tony started doing CPR, and it was passed off at one point to Firefighter Kelly. Firefighter Kelly at that time was a BLS EMT. Firefighter Flamati was a paramedic. They're going to move towards Firefighter Kelly performing CPR because at that time his skill set was not as advanced as Firefighter Flamati's, as Tony's. But they did switch off. That is a routine cardiac arrest. We switch off compressions.
But the video that Mr. Brennan showed you was earlier in time, a few seconds or a minute or two earlier.
Yes, sir.
You'd agree with that, correct?
I would.
And firefighter Flamati had not begun CPR, had he?
I don't believe so.
That's right, he hadn't. But that's the time that my client walked over your general area, correct?
Correct.
Before CPR was started, correct?
CPR was started immediately, sir.
Can we wrap this up?
I don't know if we can, Judge.
Give you a couple more minutes.
Do you understand the confusion?
Objection.
Sustained.
All right, a couple more questions on this. The video that Mr. Brennan showed you,
Yes, sir.
and you pointed to and said, oh, that's the time when she walked over and said the statement.
Yes, sir.
Remember that?
I do.
Firefighter Flamati was not even kneeling down giving CPR, was he at that point?
No,
The answer is yes or no.
no.
Okay, he was not. Later, as the video continues to run, at some point, we see firefighter Flamati enter the screen, kneel down in that bright, reflective yellow jacket, and begin CPR, correct?
Yes, sir.
You had previously said that when you heard the statement and she walked over to you, it was when firefighter Flamati was giving CPR, correct?
Yes, sir.
And at no point, you'll agree with me, we just played the video, at no point after he started giving CPR did my client come anywhere near you. Isn't that what the video showed?
That was the segment that you showed me.
You indicated on redirect that Mr. O'Keefe did not have any injuries to the left side of his body.
Not that I recall.
Isn't it true that in addition to the egg on the right side of his head, he also had a black eye on the left side?
I remember that the swelling had started to, it's referred to kind of as raccoon eyes. It's a bruising of both eyes.
Do you remember
battle
saying-
signs.
Do you remember saying, in answer to the question, did it look like, in addition to the egg on the right side of his head in the front, did he also have a black eye on the left side? Your answer is, if memory serves correct, yes.
Yes, sir.
So it's not true that he didn't have any injuries on the left side of his body or face, correct?
That swelling kind of migrates over time to both sides. That is a common occurrence for both eyes to be swollen.
Did he have an injury to the left side of his face?
He did not.
Did he have a black left eye?
Yes, he did.
Would you consider a black eye an injury?
Yes, sir.
Let me ask you the question again then. Did he have an injury to the left side of his face?
Yes, sir.
Thank you. One last question. You indicated that it was a chaotic scene outside on that front yard.
Yes, sir.
Fire engines, ambulances, patrol vehicles, engines running, diesel engines, flashing lights, people screaming, people talking over the howling wind, correct?
Yes, sir.
Did you ever see the homeowner come out the front door?
Don't recall.
You don't recall, or you didn't?
I have no idea who the homeowner is.
And you never saw anybody come out the front of the house?
No, sir.
That's all I have.
One issue. Briefly.
I want to see counsel at Sidebar.
Sir, in Mr. Jackson's questions, he asked if you had ever said that you heard the defendant say, "I hit him," separate from when she approached you. Do you remember previously testifying that you heard her saying, "I hit him in the background," separately from you?
Yes, sir.
You remember testifying that before under oath
Yes, sir.
in court?
I do.
Anything, Mr. Jackson?
Yeah, just a second, Your Honor. Thank you, Your Honor, if I may.
Yes.
Just a quick question, Firefighter Nuttall. When you were asked to recite your memory of that day on February 8th, 2022, just 10 days after this incident, did you ever say that you heard in the background, "I hit him" over and over again?
I don't recall.
All right.
When you testified at the grand jury, last question, when you testified at the grand jury, did you ever say that?
I don't recall.
But again, your memory is better now than it was then. Right?
Yes, sir.
All right. Firefighter Nuttall, you are all set. Thank you, ma'am. Do you have something for the court reporter to mark?
We can put it on a zip drive. We can discuss collecting all the clips and putting them on the same zip drive, or we could use different zip drives, whatever the court's preference is.
So we need something. So we need something physical. You can play it and then we'll mark it.
Ms. Gilman, do you have a separate clip?
Jim, is that right?
Thank you. I can have this marked, Your Honor?
Thank you. All right, Ms. Roberts, please. Okay, thank you.
We'd like to play this first and then call Ms.
Oh,
Roberts.
okay, I'm sorry.
Thank you, Your Honor.
I remember it, but I question, do I remember it because it's been relived so much? I mean, when I see the video of me driving from the waterfall, like what I just described, tapping the brakes when I crossed the intersection, Washington over Sherman Street, do I actually remember that I kind of slowly proceeded through that green light? No, I don't actually remember that. But I've seen the video so many times that you then question, did I remember on my own? Or was my memory jogged? But I also wondered, did I say, could I have hit him? Or was it told to me that I said I hit him? And I knew I never could have said that, so the closest I must have said was, did I hit him? I know I said I hit him, but did I really say it as many times as law enforcement's claiming I said it?
Thank you. I'd now call Kerry Roberts.
Raise your right hand. Do you solemnly swear the evidence given to the court and jury in the case now here is for the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You may take a seat.
All right, Mr. Brennan, whenever you're ready.
Thank you, Your Honor.
Good afternoon, Ms. Roberts.
Good afternoon, ma'am.
Good afternoon.
Could you please introduce yourself to this jury?
Hi, my name is Carrie Roberts.
Ms. Roberts, where do you live?
I live in Canton, Massachusetts.
How long have you lived in the area for?
I was raised in the Boston area, North Shore, South Shore. I went to high school in Braintree, and I moved to Canton about 12 years ago.
Do you live alone?
No, I live with my husband and 2 children.
How old are your children presently, this day?
My son is 13, my daughter's 15.
Do you work?
Yes, I do.
Without identifying specifically where, can you share with us a little bit about what you do?
I'm an executive assistant, and I've been with my company for 18 years.
Ma'am, if you could just move the microphone just a tiny bit closer. Thank you very much. You have 2 children, you're
Yes.
married,
Yes,
and you live in the area.
yes.
I want you to tell us whether you know a person by the name of John O'Keefe.
Yes, I do.
Would you be willing to share with us when you first met Mr. O'Keefe?
Well, I went to high school with John in Braintree. He played soccer, I played soccer, so we probably hung out in middle school, but we went to 2 different middle schools. And then I hung out with him more in high school. He was a year older than me. His sister was 2 years older than him in school, and his brother was younger, so at some point I was in high school with each of his siblings.
Did you at some point become friendly with John O'Keefe?
Yes.
Could you tell us about that?
When his sister Kristen passed away, and then her husband Steve passed away, they lived in my neighborhood. John took over for the children and moved into my neighborhood as well.
When John took in the children, did you offer any assistance or any help to him?
Yes, before John was even going to take over, he was going to potentially move in with his brother-in-law and the children to help out. And then when his brother-in-law passed away unexpectedly, John took over, and I jumped in because I was a friend from high school that he knew, and he had all kinds of people helping, but he sort of said, I'm going to lean on you for right now because I know you best. And I knew his parents and his siblings, and so I introduced him to my husband, and we jumped in. It was, preschool drop-offs, preschool pickups for my son and his son, and just from then until the time of his death, we were just friends, very close friends, and we hung out all the time. The children hung out all the time, and he was the emergency contact list at my children's school to call if something had happened.
Were you close friends before he took over the care of the children?
No, I wasn't very close friends with him then.
Were you close with his family before he took over care of the children?
No.
Did your friendship with him develop after he took care of the children?
Yes.
You mentioned you have a son,
Yes, I do.
and is your son the same age as John's nephew?
Yes.
Was there any common interests or activities that engaged your son with John's nephew?
Well, they went to in-home daycare together. They went to preschool together. They went to pre-K together. And they went to elementary school. They've played baseball together since they were T-ball. My son plays hockey. Patrick tried hockey. He didn't like that. So we spent a lot of time at the baseball fields together.
As you spent a lot of time together and had mutual care of children, did your relationship with him grow closer?
Yes.
And can you share a little bit with the jury how close you became?
Well, John was a bachelor, and he didn't have any children of his own. So when he took over for the children, he sort of, leaned on us to kind of guide him and, all the things to do if if someone has a headache and, if there's an ear infection or, he had his mom and dad also helping as well, but I was right up the street. So if I would go to BJ's, I would call and say, can I grab you anything? If I would go to Walmart, any of the places I would go, I would call and say, do you need anything? Can I help you? Can I grab something for you? And he did the same. We just sort of all chipped in and helped.
As your friendship grew, could you tell us a little bit about your relationship with John?
John and I were very close. We spoke on the phone and hung out. He became very close with my husband as well because he was right down the street. But we just had a friendship, a very close friendship.
Tell us about the day-to-day activities and how you would try to assist John with the children.
Well, John moved across town. I don't remember when. I forget how many. Patrick, I think, was in 5th grade or 4th grade. And I would take him home with me on Wednesdays because John would be working. So it was more of a, and if he was at my house and my daughter needed a ride the other side of town, he would take her with him. We were just very close friends. We did a lot together. We would do baseball tournaments together. We would have drinks together. We would, all the things friends do.
As you grew closer to John and helped with the children, did you become closer with his family?
Yes.
And who specifically did you become closer with?
Mrs. O'Keefe and Mr. O'Keefe, his parents, and Paul I would see from time to time, but not a lot. He doesn't live in Canton. But Mr. and Mrs. O'Keefe would be there all the time to help as well. And Mr. O'Keefe would take my son and Patrick, the nephew, out to Dunkin' Donuts all the time.
Can you tell us a little more about the collective effort of other people, including his family, helping John raise these children?
There was a lot of us that jumped in to help. It was not just me. There was a lot of Kaylee's friends' parents that jumped in and helped for Kaylee, his niece, and Patrick. There was a lot of us that helped out with Patrick. All of the community all came together to help him because there was this guy that just lost his sister and brother-in-law, and he stepped in to take care of these 2 kids, and he didn't really know what he was doing at first, but he got the hang of it pretty quickly.
You have a son that shared a lot of interests with his nephew.
Yes.
He also had a niece.
Yes.
Did you spend more time helping with his nephew or with his niece?
With his nephew.
Were there other people in the community you knew of who spent more time helping with his niece?
Yes.
And who was that?
Jen McCabe.
Did you know Jen McCabe?
I had met her once. John got a discount at Reebok, so he would take the kids, he would take anyone with kids up with him to get shoes, like sneakers for back to school or whatever. So one day he did take Jen and I up to Reebok, but other than that, I never talked to her on the phone. I never saw her out. Her children are older than mine, so we never really crossed paths.
As it relates to the night of January 29, 2022, how much earlier was it that John took you out with the children and Miss McCabe out with her children to get sneakers? How many years before that?
Years, like 6 or 7 maybe.
And from that time you met Jen McCabe in the years past, did you ever spend time with her again before January 29, 2022?
No, I did not. I didn't know her.
Were you friends with her?
I was not.
Did you speak on the phone with her?
No, I did not.
So other than that one meeting, you were strangers?
Yep, that was the only time. I knew her. I knew of her. She has 4 girls, but I didn't know her.
At some point, as you were part of John's life, did you learn that he was dating a person by the name of Karen Reed?
Yes, I did.
And do you see that person here in the courtroom today?
Yes, I do.
Could you point her out and describe an article of clothing that she's wearing?
She has a black suit jacket seated at the front table.
When did you first become familiar or know about Miss Reed?
July, I think it was, of 2020. John, we were having people over, and so I invited him, and he said, I'm going to bring Karen over. And I was like, I don't know who that is, but okay. He assumed I knew because he had been dating her for a little bit, but it was COVID, so we didn't see him very often during that time. So Karen came over that night.
And this is early 2020?
I think it was summer, so I think it was around June or July.
Briefly, just tell us a little bit about where and the circumstances of meeting John and Karen for the first time.
They came over to my house, and we hung out on the back porch, had some drinks. There was music. Kids were around. Just a nice, normal summer night. We had other people over as well.
Over the next coming months, did you become more familiar with the defendant?
Yes.
Did you see her more often?
Yes.
And could you generally describe for the jury how you learned more of her and saw her more often?
She would take care of the kids a lot. Mainly, well, not mainly Patrick, but not mainly Kaylee either. She helped out a lot with the kids. So if we were at baseball, she would come to all the baseball games, or she would drop off or pick up my son or Patrick if they were going to the golf course or the driving range.
Would you see her during events with your son and John's nephew?
Yes. We did baseball tournaments and
So when you go to baseball tournaments, would that be away, an overnight type trip?
one of them was down the Cape.
How often would you spend time with John and the defendant?
Not that often together, but John would stop by himself. My husband would go out more with John, but I didn't spend much time with the two, not a lot of time outside of the baseball field.
Did you become friends with the defendant?
We were friendly.
Did you ever spend time alone to go out or socialize?
I did not.
Would you see her when you would pick up or drop off kids, or she would pick up or drop off kids?
Yes.
Did you ever speak to her on the phone?
Yes.
In relation to what?
Corresponding with the kids, pick up, drop off, mainly Ryan and Patrick, not about Kaylee.
Did you ever spend any important dates or times or holidays with John and Miss Reed?
No.
I want you to take us ahead to January 28th, 2022.
Okay.
On January 28th, 2022, do you remember that day?
Yes.
Generally, what do you remember about the day of January 28th, 2022?
There was a blizzard coming, and it was my daughter's friend's birthday. So we were going to be going out celebrating that night, but we did it on the early side because there was a blizzard coming.
What was your plan for that evening?
We went bowling. We got dinner, then we went bowling, and then I came home because I wanted to be in before the snow started.
Had you communicated in any way with John that day?
Yes. He texted me. My son had had an issue at school. Patrick had been dismissed, I think, for a doctor's appointment. So he did text me to see how my son was doing.
Did you simply text, or did you get a chance to speak to him that day?
I believe we just texted.
Did you go out that night after bowling?
No, I did not.
Was your husband home?
Yes,
Did he go out that night?
he did. He went out with John.
And do you know where he was planning on going?
They went to McCarthy's, a bar in Canton Center.
Had you been to McCarthy's before?
Yes.
Can you just briefly describe what McCarthy's is?
It's a restaurant bar. There's a large bar in the middle, the seating on the left and the right. It's right in the center of town.
Do you remember about what time your husband went out?
I do not remember exactly. I don't know if I got home and then he went out, or if he was already gone when I got home. I don't remember. But it was he went out around the same time that I arrived home, which was on the earlier side.
How many times had you been to John's home, would you say, over the past couple of years before this night?
Oh, many.
Many times?
Many times.
Were you familiar with the house and the driveway?
Yes.
May I approach, Your Honor?
Yes.
Should I return to the podium and ask the questions,
You
Your
can
Honor?
ask them from there.
Thank you. Ma'am, I'd ask you to take a look at that photo in front of you. Do you recognize what is in that photo?
That is John's house.
Is that a fair and accurate depiction of how his house looks?
Yes, it is.
I'd like to move this to evidence, please.
Okay, any objection?
No objection.
Six.
May I publish to the jury, Your Honor?
Yes.
Thank you. Thank you, can take it down. I've shown you a second photo. Do you recognize what's in that photo?
Yes, that's John's driveway.
Is that a fair and accurate depiction of how John's driveway appears?
Yes, it is.
I'd move that into evidence.
No objection.
Okay.
Exhibit 7, so marked.
May I publish?
Yes.
Could. Thank you. I'm showing you a third photo. Do you recognize what's in that photo?
Yes.
And could you share with the jury what's in that photo?
It's the side of John's house looking up from the driveway.
Is there anything you notice on the side of the house?
The lights or the Ring camera?
Are you guessing, or do you know that's a
No,
ring
I
camera?
know. I know there's one there
And how do you know that?
because I got a Ring camera and I could look and see who was at my door. And then he said, "Why didn't you tell me about these things?" So he bought one.
I move to introduce this photo.
Okay,
No objection.
thank you.
Exhibit 8.
May I publish, Your Honor?
Yes.
Ms. Roberts, with the laser pointer, could you just point at the picture and show where the Ring camera is?
On this screen?
Yes, please.
Whichever one you can do.
Okay. Why isn't it working?
Nope.
It's on.
Okay, well, you know what, rather than use the pointer, why don't we describe, can you describe where you see the Ring camera on that picture?
It's in where the two lights are under the top window.
Okay, thank you. We could take that down, please. How many times would you guess you had been over to his house?
I don't know. More than 50,000. I don't even know. A lot. It was weekly.
That night, you told us that your husband went out to meet John at McCarthy's, a bar.
Yes, he did.
Do you remember your husband coming home that night?
Yes.
Do you have any memory of about what time he returned?
I'm guessing, but somewhere around 10:30.
So I'm not going to let you guess. Do you know? Do you have a...
I don't know. It was around 10 or 10:30. I can't be exact.
Did you see him come home?
Yes.
What was the forecast for that night and the next morning?
There was a blizzard coming.
Was that part of the decision-making of going out or staying home?
Yes.
At that time, when your husband came home, did you look outside? Do you have any memory of what the weather looked like around 10:30?
I remember the snow started to fall somewhere around 12 because I remember looking out the window and I could see it starting.
And that was the beginning of the snowfall?
I believe so.
What was the weather out that night?
The weather that night, I think, was fine. It was cold, but it wasn't snowing yet.
I see. I want to move forward ahead. At some point that night, did you go to sleep?
Yes, I did.
Did you sleep through the night, Ms. Roberts?
Yes, I did.
Okay. At some point, did you wake up?
Yes, I did.
I want you to tell us what was the reason that you woke up.
I got a phone call at 5 o'clock in the morning from Karen Reed.
Were you expecting a call?
No, I was not.
Had you ever received a call at 5 in the morning from Ms. Reed before?
No.
Share with us what happened that morning. What did you hear?
Karen called and the first thing she said was, Carrie, Carrie, John's dead. And then she hung up. And then,
When she said that, did you have a chance to have a conversation with her?
no, I did not.
Describe her demeanor when she said that.
She was yelling loud enough, my name, I think it was 3 times, it might have been 2. She was yelling loud enough that she woke my husband.
Your husband was sleeping next to you?
Yes, he was.
Was she loud, yelling, screaming?
Yes, she was very loud. She was screaming.
After she said, Kerry, John's dead, did you know what she meant?
No,
And did you say this was around 5:15?
this was at 5. She called me at 5 on the
5.
dot.
After she hung up, what did you do?
I was half asleep still. I didn't know what was going on. So I started to get up, and I think I tried to call her back. I know I tried to call her back, but I don't know exactly when, because I was like, what? So my husband said, what was that? I said, I don't know. Something's going on. I don't know what's going on. That was Karen. And then I tried to call her back. I know I tried to call her back, but I don't know if she answered or if she called me back the next time I spoke to her.
After you or she called you again, did you have another discussion, or did you hear her say something else the second time you spoke to her?
Yes, the second time she said, I think something happened to John. I think he got hit by a plow. He didn't come home last night. Kaylee was home. He would never leave her by herself, and I was not supposed to stay at the house last night. So I think something happened to him.
Did she say anything about drinking?
Yes, she said, we drank so much, I don't remember anything from last night. And I said, okay, where are you now? She said, I'm driving. And I said, you need to go home. Where's Kaylee? And she said, at home. I said, you need to go home and be with Kaylee. She cannot handle this, thinking, her uncle's missing. I said, you're going to get a DUI. You need to go home.
Was there anything else in the conversation that she said to you at that time?
She said, I'm going to drive to your house. Would you drive my car? And I said, yes. So at that point, I started to get dressed. I turned on the automatic car starter so it would warm up. Told my husband, I don't know what's going on. John didn't come home. And so I think my husband tried to call him, and I tried to call him. And my husband said, you're not going anywhere. It's a blizzard. He's probably on somebody's couch. And I was like, I know, but she's really upset. I'm just going to go. She wants to come here. I'm going to drive her car. And then I went out to my car and sat and waited for her.
When you called John, did you get any response?
No, I did not.
As you were waiting for the defendant, did you make any other phone calls?
I did. When I was in the car, I thought to myself, well, she thinks he got hit by a plow. I'm going to call the police and see if there was any accidents or maybe something happened. They brought him in. And I spoke to the officer who said, no, nothing of that sort. I've been here all night. And then I called the Good Samaritan Hospital and Milton Hospital to see if they had anybody that was taken in an accident.
When you called the police to look for Mr. O'Keefe, did you call 911?
No, I called the non-emergency line.
Do you know if that call was recorded?
I believe so.
I'd like to introduce an exhibit.
Okay. Any objection?
No objection, Your Honor.
Okay.
Exhibit 9.
When you called the police, what was your level of worry at that point?
I wasn't super worried. I mean, he didn't come home, but they were out drinking, so I assumed, like my husband said, he's probably on somebody's couch.
The second call you had was Miss Reed. Can you describe her demeanor in that second call?
She was frantic. She was frantic. I mean, she couldn't find John, so she was very worried.
How soft or loud was that phone call?
It wasn't as loud as the first one, but it wasn't a regular conversation.
With the court's permission, I'd like to play the exhibit of the call.
Okay.
Hi, friend said calling because my friend's boyfriend did not come home last night. We were at Waterfall, and now she is calling me hysterical because she doesn't know where he is. You didn't take anybody outside the name of John O'Keefe, did you?
John O'Keefe?
Yeah, he's the Boston cop, and it would be on post, so.
No.
And she probably got a ride and passed out at someone's house, I don't know, but.
Yeah, no, we didn't lock anybody up or anything like that. And where does he live?
He lives on Meadow, down the southern.
He lives on Meadow, Pleasant. Okay, and where's the white home? You said your girlfriend?
With his girlfriend, yeah, they were out having drinks, and then she left and expected him to come home at some point, and he never did.
Yeah.
And so I said to her, you know, my husband had been out with them earlier in the night, but then he obviously came home, and he has custody of his niece and nephew because their parents passed away.
Okay.
And so she's home with the niece and nephew, and they're old enough to be home. And so she's nervous because she never even called him.
Yeah.
So she's like, I feel like something happened, and I said, okay. Well, so call the area hospital, and nobody happened. I personally think he probably picked him up and he passed out. I don't know.
Yeah, where he didn't drive last night?
No.
No. Okay. Again, it's more, it would be driven by you. She would have to, call in, come to the patient, and talk to us. But as of right now, it's more, he just didn't come home last night. Is this common sometimes happen with him?
No, that's why. That's he didn't call his niece. That's kind of why she's more freaking out. So I figured I called the area hospital and then I would call Kansas police just to make sure he didn't get picked up. But like I said, he's not some police officers or any of those bunch of people. If anybody could pick him up,
Yeah.
please take it off.
Okay.
Again, we're having a bullshit party or something.
Yeah, no. Unfortunately, I wasn't there. I was stuck here. But we didn't get any calls, anything like that. Nobody was arrested or anything like that. All righty.
All right, well, thank you.
All right, no problem. Good luck.
Okay,
See ya.
thank you. Bye-bye.
Were you in your car when you called the police station and the hospitals looking for John?
Yes, he was.
Do you know at that point whether anybody else had called the police station?
No, I don't know.
Do you know at that point if anybody else had called any hospitals?
I don't know.
How long did you wait in your driveway?
I don't know. I'm sorry.
Okay.
Maybe like 7 minutes, 8 minutes.
What were the conditions like out that morning?
It was bad. It was in the middle of a blizzard.
When you were outside in your car in the driveway waiting, describe the lighting conditions for us.
It was still dark out. It was 5 o'clock in the morning and it was snowing, so it was not great.
How was the visibility?
Not great. It was coming down really fast at that point.
You said that night when you went to bed, the snow just started. Had snow accumulated at that point?
No, I don't think so. It was just starting to stick.
I'm sorry, that was the night before, but at this point when you were in the driveway, had the snow accumulated?
Oh, yes.
Do you know how many inches it was?
No, I don't.
Okay.
Enough that the plows are out.
As you were waiting for the defendant, did she arrive at your house?
She did not.
What happened?
Again, I don't know if I called her or she called me, but eventually we connected on the phone and she said, I said, where are you? I'm waiting. And she said, I'm at Jen's house. And I said, Jen who? And she said, McCabe, she's going to drive my car. And I said, okay, well, listen, they don't want cars on the road because it's so bad. I'm already in my car. I'll come there to Jen's house, stay there, and we'll follow each other and we'll go back and drop your car off. Did you look in the house for John? Could he just be in the house, passed out somewhere? And she said, no, she hadn't looked in the house. So I said, okay, now I'm gonna come to Jen's. We're gonna take the car home, drop it off. We'll check around the house. And then, I don't know what the next step at this point was. I just wanted to check the house.
At the time you directed that you were going to meet at Jen McCabe's house and then drive to John's house, was there any suggestion by the defendant where she wanted to go?
I didn't know where Jen's house was. I knew the street. I had dropped Kaylee off or picked her up a few times. So I said, stay on the phone with me, so I don't know which house it is. And so when I got there, I pulled in the driveway, and there was some conversation about,
Can I back you up and just ask you a little bit about the drive there? I don't
Yep.
mean to interrupt. When you left your house, you talked a little bit about the weather conditions. How long did it take you to get from your home to Jen McCabe's?
oh, it's quick, probably 4 minutes.
What was the driving like?
It was not good driving. That's why I didn't want 2 cars on the road.
Did you have any difficulty driving through that storm?
No, I mean, it was treacherous, but I was in 4-wheel drive. I have an SUV.
You mentioned you didn't know exactly where Jen McCabe lived. Had you been there to drop off John's niece before?
Yes, but I didn't know which house it was, because when I picked her up before, she was either getting out of the car at the driveway or waiting at the end of the driveway, so I didn't know which house it was.
I think I interrupted you, but were you telling us that as you drove to Jen McCabe's house, you were on a Bluetooth, on an open conversation with her to help with directions?
Yes, Jen and Karen were in Karen's car, and I was on the phone essentially with both of them.
Do you know what type of vehicle the defendant was driving at that time?
A Lexus SUV.
As you drove over to Jen McCabe's home and you had some guidance finding it, did you hear any conversations in that open line with, or even any statements by the defendant?
I remember when I pulled in behind her car in Jen's driveway, and at some point Karen said, my taillight, and I looked, and Jen she must have had the brake done because you could see that there was missing taillight.
When you say missing taillight, was it merely cracked?
No, there was a piece missing.
Could you see that as you were parked right behind the defendant's SUV or Lexus?
She must have been applying the brakes because you could see it, but there was a lot of snow.
When you saw that the taillight had a missing piece, did you say anything?
No,
Did you think anything of it?
no.
How long were you parked behind the defendant's Lexus while it was parked in Ms. McCabe's driveway?
Not long. We were just, I pulled in, and then we stopped, and then the next plan, at some point in that conversation as well, or maybe on the ride, because now we're heading to John's house to drop a car off. I pulled out of the driveway, Jen pulled out, and I followed behind all the way to John's house. And at some point, Karen said, I left him at Waterfall. And I heard Jen say, no, I saw you pull up in front of my sister's.
Was anything else said about the broken taillight?
No,
You followed Ms. McCabe?
yes,
Where did you go?
to John's house,
Did you arrive?
yes.
I want to ask you some questions about when you arrived and what you did next.
Okay.
When you arrived at Mr. O'Keefe's home, you were in 2 separate cars. Who pulled into Mr. O'Keefe's driveway first?
Jen pulled Karen's car in first.
So Ms. McCabe was driving the Lexus,
Correct,
and the defendant was in the passenger seat?
yes.
After you both pulled in, tell us what happens next.
We went, I wasn't sure if it was, at some point Karen showed us the taillight up close, but I didn't know if it was when we arrived or when we left. But we went into the house to look for John.
When the Lexus was parked by Ms. McCabe in Mr. O'Keefe's driveway, was it facing the street or facing away?
Facing where the basketball hoop is, not facing the street.
Would like to approach?
Okay.
Going to show you a photograph. Do you recognize what's in that photograph?
Yes, that's John's driveway. That's Karen's car on the left and John's car on the right.
Do you recognize both those cars?
Yes, I do.
Do you recognize that photo as a fair depiction of his driveway?
Yes,
Do you recognize it as a fair depiction of the motor vehicles?
yes.
Now, when you went there that night and you pulled in behind Ms. McCabe and the defendant, is there any differences between how that area looked when you pulled in as opposed to that photo?
Well, it was the early hours of the morning, so it was dark out, and there was much more snow. And there was
Other than
snow
this-
coming down.
I'm so sorry. You want to finish?
Nope.
Other than the snow and the lighting, is there any other differences?
Nope.
I'd like to introduce this as an exhibit, please.
All right, there's no objection, Mr. Jackson?
No objection. With the court's permission, I'd like to publish.
Okay.
And to help us understand, you see on the left is the house.
Yes,
There's a motor vehicle in the middle of the driveway, but it's the vehicle to the left.
yes.
And whose vehicle is that?
That's Karen's.
Is that where it was parked that night when you went into the house?
Yes,
In the motor vehicle to the right, you recognize that?
that's John's car or SUV.
Thank you, you can take that down. I'm showing you a second photo.
Okay?
Do you recognize that photo?
Yes,
What is it?
it's the back of Karen's car.
Does it look like a fair and accurate depiction of her car as it appeared that morning in the early morning hours to you?
Yes,
Do you notice anything that's distinguished in that photo?
the piece that's missing in the taillight.
Which one?
The right passenger rear.
Do you know when, I'm sorry, do you know when this photo was actually taken?
I do not.
Although you don't know when it was taken, is that a similar depiction to your memory of how it appeared that morning at 5?
Yes,
Or a little after 5?
yes.
I move to introduce this exhibit.
Okay.
No objection. With the court's permission, I'd like to publish.
Yes.
11 somehow.
We could take that down, please. After you arrived at Mr. O'Keefe's house, what was the plan to go inside? What were you looking to do?
To go inside and look and see if he was passed out somewhere. So we went in through the garage, and I started looking. I think Jen ran upstairs to Kaylee's bedroom, and I just started looking through the living room. Basement door was locked from the inside, so I knew he wasn't in the basement. And then I checked the other living room. He has a big house. Then I went to the top of the stairs to check his bedroom.
As you looked around, what was your mood?
What was my mood?
Yes, were you calm?
I mean, I was worried, so we were, at this point, Jen had already established that they went to her sister's.
Sustained.
Okay.
Jen had already.
Now, let
Hold
me ask
on,
the question.
Ms.
I'll ask
Roberts.
the question better. My apologies. How many rooms did you look through in John's house?
1, 2, 5 or 6.
Did you see Miss McCabe looking in rooms as well, searching?
She went upstairs when I was looking downstairs.
At some point, as you were looking, did you see the defendant?
Yes,
Was she looking with you?
she was in John's room.
What was she doing?
She was just standing there when I came up to the top of the stairs.
Did she say anything?
No,
Did she do anything?
no,
Was she searching?
I don't know. She was in the room.
What happened next?
At some point, Jen earlier had said,
Well, let's not talk about what was said. Okay. Let's
Well,
just talk about
the plan
best
at
you
this
can,
point
your-
is
your
to go to
memory of what was
34
done.
All right,
Fairview.
Ms. Roberts, I know that I'm just going to ask you to wait for a question
Okay.
because we can only get one person at a time. So next question, Mr. Brennan.
Again, my apologies. And so as you're looking through the house, you don't find John. What happens next?
the plan was to go back to Jen's sister's house.
Who made that plan?
Karen wanted to go back there.
Well, tell us a little bit about that. How did that conversation come up, and share with the jury what was said?
And the car ride to Meadows, Karen said, I left him at Waterfall. And Jen said, no, I saw you pull up in front of my sister's. So then Karen said, we need to go back to your sister's. And I said, no, we're going to go to Meadows, and we're going to drop the car, and we're going to look there. Then we'll go there if we don't find him.
When you were at the house, Meadows, John O'Keefe's house, and you didn't find him, was there any further conversation about what the next steps would be?
I said, let's go. He's not here. But I didn't know where Jen's sister lived, so we got into the car. Jen was in the passenger seat. I was driving my car. Karen was in the back seat.
Did you
And Jen
begin,
was giving directions.
did you begin your way towards Meadows?
Yes,
And it was Miss McCabe who was giving directions?
yes.
As you began driving to head towards Meadows, in addition to trying to drive, were you doing anything like looking or searching?
Well, yeah. We were looking on both sides of I was looking on both sides of the road in case he was walking home.
Did you see Miss McCabe searching?
Yes, she was looking out as well.
Describe a little detail about what you saw Miss McCabe doing.
She was looking out the window as we were driving, so was I, as I was driving.
And where was the defendant during that time?
She was in the back seat.
Was there any conversation, comments, statements?
Well, she would be in the back seat, and then she would be in between Jen and I, in the back seat, and then in between Jen and I. She was just very frantic.
Okay. Was she saying anything?
There was conversation on the way there.
Okay. Was she looking as well? Did you see her looking out the windows like you and Jen?
I don't know if she was because she was in the back seat.
Okay. As you drove to Meadows, what was the visibility? The same or better or worse?
No, it was poor.
Did you make your way towards Meadows?
I did.
As you finally got to Meadows, was the house on your left side, your side, or on the other side?
Are you talking about Fairview or Meadows?
I'm sorry, Fairview.
Okay. The Fairview house came up on the left-hand side.
Before you got to the house, is there a tree line between that house and the house before it?
Yes. There's a cluster of trees and bushes.
All right, take us back. I want to talk about that morning. As you're driving and approaching Fairview, tell us what you hear, what you see, what's happening.
Jen's giving directions, and it was really bad driving. I was white-knuckling because it was getting slippery. Karen wouldn't put on her seatbelt because she was in between us again the whole ride and then sitting back, but she was worried because we weren't finding John.
Were you having words?
Yes.
Tell us.
I said to Jen, where are we heading? And she said, my sister lives on Fairview. And I said, where is that? She said, off of Chapman. I said, oh, okay, near Spring Lane. At some point, Bella's mom came up.
Tell me what that means.
I didn't know who it was, but it was one of Kaylee's friends, Bella's mom. Well, the directions, at some point Karen was talking about Bella's mom to Jen, saying she never liked me. I didn't know who this woman was that they were talking about. But apparently Bella's mom lived near where Jen's sister lived on Fairview.
Did you learn any more about the relevance of Bella's mom?
No. Oh, well, I think John had dated her.
I'm going to allow it.
So as you approached Fairview, tell us what happens.
As we approached Fairview, at the house. You mean the house or the street?
Yes, the house.
The house. Jen said, my sister's house is right up here. And I said, okay. And as we approached the house, Karen from the back seat is now screaming, there he is, let me the F out of this car. And she's out kicking the back door to get out.
When you heard the defendant scream, there he is, and started kicking the car door, did you see anything?
I did not.
Did you see anybody?
I did not.
Did you look?
I looked.
Was there anything that impeded your ability to see far?
No, it was just snow.
How far could you see when she was yelling, there he is?
How far could I see?
Yes.
I mean, the visibility wasn't great.
Okay. Was she pointing or giving any direction?
No, she just said, there he is.
Okay. What happens next?
And then I unlocked the car. I looked over, I didn't see anything, and I unlocked it so she could get out of the back seat. I looked at Jen and I said, she's crazy. And then I turned around and watched, and she ran over to a mound of snow.
When she started running, before she got anywhere, did you see anything at that point?
I did not.
Were you looking?
I was looking. She said, there he is, so I'm looking around to see where he is.
And you could see nothing?
I did not.
Did you see her run around or directly?
She ran right over to the mound of snow.
Could you tell what the mound of snow was from the car?
Once she got to it, yes, it was. Once she got to it, you could tell it was a mound of snow that was the length of a body.
Okay.
All right, I'm going to stop you there, Mr. Brennan. I need to see counsel at sidebar for just a minute, please, regarding Sidebar. All right, so Ms. Roberts, we're going to have you come back tomorrow.
Okay.
Jurors, we're going to break for today, so we're going to send you home